I'll get us underway. Good afternoon, everyone. Today is Tuesday, March 2nd, 2021. I'd like to take this opportunity to welcome everyone to the House Economic Matters Committee. We have we have 7 bills before us, it appears. The first bill will be House Bill 1370 with Delegate Smith. Before Delegate Smith gets started, just a couple of housekeeping notes. To the people that are part of the Zoom, remember the chat is just for the members and staff so that we can communicate with one another. Also, there's a box to your left, a blue box that has your time limit. When it gets to 000, we need you to respect that. We got a number of witnesses signed up today, so just please keep in mind that that timer is not a recommendation, but it is in fact to let you know when your time has expired. And with that, I would say let's get started. Delegate Smith. Is Delegate Smith with us? Okay, we will come back then and go to Delegate C Branch for House Bill 972.
Good afternoon, Chairman Davis, Vice Chair Dumais, and the members of the Economics Matters Committee. I'm Delegate Chanel Branch, and I come to you today to ask for your support for House Bill 972, Real Estate Brokerage Services Prohibition. This bill prohibits a real estate broker from providing brokerage services relating to any new transactions involving certain property until certain trust money has been distributed in accordance with certain provisions of law, under certain circumstances and generally relating to the real estate brokerage services and trust money. This bill provides transparency and resolution to the earnest deposit transaction process. An earnest money deposit is an amount of money given by the buyer to show they're serious about purchasing the home. It is also known as a good faith deposit. These funds are collected to protect the seller if the buyer backs out. It is typically around 1 to 3% of the sale price, and it is held in an escrow account until the deal is complete. If the earnest deposit is to protect the seller in a real estate transaction, then what about the buyer? How can we be sure that a buyer will receive their earnest deposits back if a home does not pass inspection because it is found to have major structural damages, and if the buyer cannot come to an agreement with the seller to make necessary repairs? It is important to have the proper contingencies in place to protect both the seller and the buyer. I believe this bill will provide the necessary protections to resolve matters such as this. So today I ask for a favorable report for House Bill 972. Thank you.
Thank you, Delegate Branch. Let me go to our first witness, Anthony Moorman.
Yes, my name is Anthony Moorman. I'm the broker and owner of Century 21 Certified Realty Group. Good afternoon, Chair Davis, Vice Chair Dumais, and committee members. I have been in the real estate business for over 30 years. I currently hold a broker's license in Maryland, Pennsylvania, Washington, D.C., and Nevada. One of my biggest headaches in my day-to-day activities is when a real estate transaction falls through due to a less than favorable home inspection, or the buyer's financing isn't approved and the seller tries to retain the earnest money deposit. In most cases, our standard Maryland Association of Realtors standard contract includes contingencies for inspections and for financing. The process for the buyer to get their earnest money deposit funds back would have to include mediation and or legal hearings that I've seen take up to years to conclude. In agreement with HB 0972, I believe it would be great if the seller could no longer market their home with a licensed realtor until the EMD issues are resolved. Please give HB 0972 a favorable report.
Thank you very much. Randy Holt. Is Mr. Holt with us? If not, Wayne Davis. Is Mr. Davis with us?
Yes, I'm here. Good afternoon, Chair Davis, Vice Chair DeMais, and committee members. My name is Wayne Davis, and I'm testifying in favor of House Bill 0972. I'm a 26-year real estate veteran and a broker of United Real Estate Executives located in Owens Mills, Maryland. I support this House bill because I've encountered several situations where the buyer's earnest money deposit was held in escrow because the seller refused to sign a release agreement for a transaction that didn't go through, even if the buyer was not at fault. In most cases, these deposits are the buyer's entire savings and is needed to move forward with the purchase of another home. Currently, the seller and buyers must sign a mutual release of contract and a release of deposit to terminate a contract of sale. Depending on the circumstances, the seller will sign the release of contract, but not the release of deposit. This enables the seller to move forward with actively marketing and selling the property to a new buyer. Meanwhile, the original buyer's funds are still held in escrow. As a broker, we cannot authorize the release of these funds to the buyer unless the seller is in agreement and signs off, which holds up the buyer, but not the seller. Please give House Bill 0972 a favorable report.
Thank you very much. Bill Castelli.
Thank you, Mr. Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. And we are signed up in opposition to the legislation. We appreciate Delegate Branch reaching out to us. We do agree that there result from the deposits, sometimes with buyers, but we do think that the approach that this bill takes actually will flip some of those problems that the buyers are having and create some problems with sellers. If a seller's prevented from relisting their property because there's a dispute, and it may be a valid dispute. I mean, there are certainly situations where the seller's at fault, but there are also situations where a buyer may be at fault, and a seller could, because of the buyer signing a contract being at fault, that seller could get tied up in his ensuing transaction. So we think we think what this would end up happening is that because a seller wouldn't even be able to relist their property until the earnest money dispute is resolved one way or the other, sellers really don't have a choice. They just wouldn't, they would just release the deposit money. And in that case, if they were the person at fault, then there's really no point to even having an earnest money deposit at all. Some people might think, well, maybe that is the way, because right now under current law, there is no requirement for a buyer to offer earnest money deposit. They actually offer a small amount of earnest money deposit as a way to protect themselves. But if they do that, then that risks, particularly in very vigorous markets, sellers choosing another contract with a higher deposit. So there are lots of different consequences to this bill, and we would encourage an unfavorable report.
All right, Delegate Impalaria.
Thank you. Bill, I'm glad you're there and glad to hear what you have to say, because, I have a house on the market. I've went through the exact same thing where these inspectors are out of control and they need to be reined in, and we need tighter regulations on them. And then include them in something like this is just the wrong thing to do. Because in my case, what happened was a chimney inspector came out, said that the chimney needed $40,000 worth of repairs, then turned around and wrote an estimate to the buyer, which is unethical. He's supposed to be a neutral party, not writing an estimate so he can make money off of it. And the chimney actually needed $400 worth of repairs, some minor pointing on the outside of the brick. And then this blackballed the house. So now the realtor feels I need to disclose this information, even though it isn't true, because I don't want to lose my license. So very nicely, I told the people, you can have your deposit back, but you have to write a letter saying that we apologize for sending this inspector. It was unethical. He shouldn't have did that. And they refused to. So right now, that's where we are. We're hung on this deposit. I hate to hold their deposit up. And I would think for a simple letter, I would have wrote the letter and had the deposit released. Now, the second time the house went up for sale, the home inspector, and thank God, on the first one, we were held up for 2.5 months on that buyer. So that really pulled the house out of a good market, put it in another. This second one, the home inspector was the uncle of the buyer, which once again is unethical. So, and of course I gave them their deposit back because I wasn't going to deal with it and it hadn't been that long of a holdup. But you see the problem with these inspectors every single day. Do you think it would be proper to include them in a bill like this? Because what I'm seeing is inspectors are being used to falsify this information to take advantage of the seller to drive the price down. What's your thoughts on that, Bill?
Well, I would say, I mean, the bill itself doesn't really bring the inspector into it. It's that's more a function of the transaction itself. And, buyers are able to have inspectors come out, take a look at the property. Where it gets caught up in the deposit dispute is that there are usually contingencies in that contract. So let's say, you have a situation similar to yours, Delegate Impalaria, where there was something about the property, material, fact that they didn't like, and they couldn't get fixed, or the parties couldn't agree, then the buyer would theoretically, under the real estate contract, unless it's an as-is contract, would be able to step out of the contract, and theoretically that deposit money could get or should be returned. But there are situations where a seller might be obstinate, might not release it, despite the fact that, it appears from from everything, all the contract language, and certainly the facts of the situation, that the buyer should get that money back. But then you have it on the other side too, where you have situations where you've got a seller who, might have another transaction that they're working on as well, and then gets held up by a buyer. Buyer ends up not being able to fulfill their obligations under the contract. That seller has got, it ends up interfering not only with their existing contract, but it also interferes with the contract on the home that they're trying to purchase as well. So that has a cascading effect, because then that second home they were trying to purchase, that, messes things up for that other party as well. So, I mean, and that's kind of the concern we have, which is that there are some unintended, we think, effects from this. We agree that there's a problem. And one of the things that we tried to talk to the delegate about was trying to figure out if there are better ways to address it than just by saying you can't relist the property. We just, we haven't hit that idea yet, though.
But there is a mechanism in place right now where you can go through arbitration, you can straighten this out. And if the buyer isn't willing to go through the arbitration and straighten it out, that's their fault. And you got to admit, there's a big difference between $40,000 and $400. And you as a realtor, now feeling obligated, you have to say, someone said this house needed $40,000 worth of a single repair, but the truth is it only needed $400. That's a black eye on that property. No one with their right mind is going to buy. So, and I've talked to a lot of realtors, and they're telling me this is happening constantly. These inspectors are so afraid of being sued that they're writing mile-long lists, and on these lists, everything. The roof has problems. It needs to be looked at by an expert. By the time the inspector's done with you, now you got to hire 20 experts to come out to see if the doorknobs turn, if the faucets turn on. And this is a big holdup especially if it holds the house for 2 or 3 months while you're waiting for all this to happen. And my feeling is, you can say, well, the buyer's not at fault. That inspector is the buyer's agent. He's hired that person. He's paid them. So they are responsible for that. And when you see the situation, because this bill to me is frightening. Basically, you're now legalizing what they're doing, where they're coming out and using that inspection to drive down the price of the home so that the buyer gets a better deal and the homeowner is basically held up. And that homeowner might be in a situation where they're buying another house. They have to drop by $20,000, $30,000, $40,000 to try to appease something that they know isn't wrong, but they're caught in contracts. So this bill is very scary to me. That's the way I feel about it.
Delegate T Branch.
Thank you, Mr. Chairman. This bill seems to be more about deposits than anything, more so than inspections. I think that nobody really likes to give back deposits, of course, so it becomes a issue. So, and listening to what you had to say, Mr. Bill, it appears that one sale, if the seller have a couple of projects going on and something happens with one or two of those, then the deposit of that one person could become affected. And quite frankly, I think it's about people's money being held up. But why don't I ask Mr. Wayne Davis if he could explain just a little further what the problem really is and why the bill is here.
Okay, so in my opinion, it's more, I understand what the other gentleman was talking about as far as a repair and things like that, but it's just about the deposit. So when someone, purchase a home, along with the contract, they have to have what's called an earnest money deposit. That's a good faith deposit that's held in escrow, typically with the broker. Now, most brokers actually hold it, have the title company hold it, so a third party. Now, what happens in the situations where, I'm thinking of, it's something had to do with the buyer's financing, which, is uncontrollable by the buyer, which they should still get their deposit back. Or if there is something wrong with the property, and we rely on professionals of that field. So it's not like we go in there as an inspector, we just get the reports back. So I do understand what he's saying about some of these inspectors, and more importantly, the contractors, because it's just like when they know you're selling a house or buying a house, it seems like the price doubles. So this is more, I think what the bill is saying, this is more of a way to give the buyer their deposit back. If the seller, if everyone's moving forward, we can all move forward, everybody can cut ties, but you still have this money that's just lingering and it's held in escrow, and we can't legally disperse it unless everyone's in agreement. So if the seller has agreed to move on and put their house back on the market and sell it to a new buyer, they should be able to release the deposit as well.
Okay, thank you, Mr. Chairman.
Delegate Walker.
I guess I just want to know, is it defined, like, are there only certain instances in which the buyer could get the money back? So is it only if it fails an inspection? I kept hearing that word. So are there only two defined reasons that would allow the seller to get the earnest money deposit back? Or is it a variance of reason which seems to go on all the time?
That question, Delegate Walker, I would like for to refer that question to
Sure.
Anthony Mormon, because he can speak better about
Sure.
the bill. Thanks.
So it's generally three different circumstances or contingencies that would allow the buyer to get out of a MAR contract. One would be a financing contingency, two would be an inspection contingency, and three would generally be an appraisal contingency. Those are generally the three things where we have issues with this. And the problem is a lot of cases it's blatant and everybody knows that the buyer's not wrong, but the seller's upset. So they understand that they can prolong this thing. They can not show up for mediation. They can, they can not respond, and there's no urgency for them. So I believe by not allowing them to put their home back on the market, it creates urgency. Yes, there will be some situations that won't be fair, but right now it's blatant disrespect in a lot of cases where it's intentional.
And to add on to what Mr. Mormon said, sometimes in these cases, when these cases go to arbitration and then sometimes have to go to court, these funds are eating up. The deposit money is being taken away from the actual buyer, and they may not have the money to even pay for the cost of court costs, lawyer fees, and everything. So sometimes in certain situations, buyers will be angry and take the seller to court just to eat up those funds. So that's why I think that this bill will kind of put urgency in the seller's side to be able to resolve these issues, so that way we don't have these types of issues happening.
All right, no more questions. Thank you, Mr. Chair. Good to see Delegate Branch, Little Branch.
I knew you were going to sneak that in. All right, that appears to be
I
everyone.
got one more if I could for this.
Real quick, Delegate, we got to get moving.
Okay. And Mr. Anthony, you said that, it's the rare case where this happens. And I would agree with you, because I've never had anybody complain to me that they were unable to get a deposit back. But I have had numerous complaints about inspectors going out trying to shake down the people who are trying to sell the house. That is a major problem. If we were taking care of that problem first, I would say that this was a good bill. But unfortunately, you're a realtor, and if someone comes out and writes a whole bunch of stuff that's wrong with the house and it's not really wrong with the house, you're obligated to disclose it, even though it's not true. You're shaking your head. So, and that's a problem. So if the seller came to you and said, look, just sign a letter that this was a bad inspection and I'll give you your money back, would you do that? I mean,
absolutely. I would have, absolutely.
Yeah. So, that's the problem, is that buyers right now are being taken advantage of by these inspectors. And these inspectors are not trained in electricity, plumbing, carpentry. They're not trained. They take a 3-hour course, and all of a sudden they're an inspector, and everything that someone works for is out there on the line. And then guess what? The next day, another inspector comes in untrained and finds a whole different list of things. So that's my problem. So thank you for being honest about that.
Yep.
All right, that concludes the witness list for House Bill 972. I believe Delegate Smith is with us now, so let's go to 1317, please. Is Delegate Smith there?
Sorry, I was having some computer issues.
Welcome, Delegate.
Can everyone hear and see me fine?
Yes.
Okay, great. Sorry about that. Good afternoon. For the record, I'm Delegate Stephanie Smith, and I'm here to present House Bill 1317. I want to say thank you to the Economic Matters Committee, and good afternoon to the Chair, Madam Vice Chair, and the full committee. Nice to be with everyone today. This is going to be a simple and straightforward bill. It's addressing barbers and the licensure of these barbers by master barbers. Under current law, an apprentice barber, if you're a master you can only have up to 3 apprentice barbers that you can employ in your barbershop overall. This bill removes that overall 3 apprentice limit, but it also increases from 1 to 3 how many apprentice barbers a master barber could support at any given moment in training. The reason why I put forth this bill is a couple of reasons. One, we have some really talented people across Maryland that are providing barbering services, but oftentimes without licensure. Some of this can be because of the cost related to it. So we want to make sure that all Marylanders are having these services rendered by people that have been properly trained and licensed. We also know that for barbering institutes or schools, this would increase their capacity to provide support to those interested in obtaining licensure for barbering, but it would also probably provide some aspects of affordability because more potential barbers could be trained than currently allowable. If you refer to the fiscal note for House Bill 1317, it notes that it doesn't appreciate a glut of barbering licensure happening, but it would also, more importantly, ensure that those who are providing those services to our neighbors and friends are doing so appropriately trained and licensed. And I also want to bring to your attention, and they will do a much better job than I, that the supporters of the bill you'll hear from shortly will be discussing how they can actually expand a workforce opportunity in Baltimore City and other communities where there are talented young people who are looking for ways to self-support. And I believe that our grooming industry provides a lot of opportunities, not only for self-expression, but to be a self-supporting Marylander. So I do hope with your careful attention to those who remain in support of the bill in their testimony, that you will give your favorable report to House Bill 1317.
Thank you very much. Corey McDaniel.
Yes, good afternoon to the committee. Oh, I'm sorry. Can you hear me?
Yes.
Oh, okay. Good afternoon.
Yes, sir.
I'm the owner of Conscious Hairs Barbershop and Natural Hair Salon and Conscious Hairs Barbering Boot Camp. I came in 2000. We started this in 2019, and the bill actually passed in 2019. What happened was that it was one word that was off, and it said student instead of apprentice. If you would go back and look at it started as House Bill 1021. And then we put it back in last year, and it was House Bill 1041. But of course, because of the corona issues, they had to wipe it off the table. But the bill did pass before. And so we had a bunch of master barbers and trainers, that people that we had under us that was ready to start as of October the 9th, October the 1st in 2019, and we had so many people who couldn't do it. But it was going like I said, it's, we only can train one apprentice right now at a time, and so now we were going to be taking on 3 at a time, and it normally takes about 10 to 12 months for that to happen. But I'm just coming before the committee and saying, look, the bill already passed. It was one word, and the state board wouldn't go for that one word, and they said, I thought that the apprentice is a student, but of course they wanted it to specifically say apprentice, and now we have fixed the problem with this bill with 1317 here today. And we just ready to go, and so we can bring more barbers on, because there's so many illegal barbers cutting in the community. They don't know anything about sanitation and many different things. They can cut hair really well, but they don't know the politics of about cleanliness and those different things, especially at a time of coronavirus and all. But we just want to be able to go ahead and perform the services as we passed it in 2019, where we thought that everything was straight, and we just want to finalize everything so that we can be able to help more people get jobs, and to be able to bring them through an affordable way to get their barbering license and bring integrity to the barbering trade. Thank you.
Delegate Arentz for some expert commentary.
Thank you, Mr. Chair. It's probably the person who will have to be the floor leader on this bill. I just had a couple of questions for you. Why from 1 to 3?
Well, because I teach a barbering boot camp right now, and it's really an apprentice prep program. We prepare people to be able to work on the floor as an apprentice, to have those skills to work on the floor as an apprentice. And right now we only can do 1 at a time. And so we can train more, we can have more barbers to be licensed at a time. But if I only can do 1 a year, then that's stopping me from doing more people at a time. So we want to be able to one of my students is here today to testify also, and you'll see when he testifies. When he testified in 2019, he didn't have his license yet, but now he's a licensed barber, and he's getting ready to take his master barber license. So therefore, he'll be able to have to take on 3 at a time, and then we'll be able to take on 6 at a time, you know, and be able to help more people go through. But it's just now a lot of people are discouraged when they find out that going to barbering school is $10,000 to $17,000. We don't have anything against barbering schools, but if you can't afford it, you can't afford it. And you know, so we can be able to help people. But I mean, people are out there, they cutting in barbershops now. And most of the good majority of people that's cutting in barbershops don't have license, you know, right now. So,
And I guess the purpose is you're hoping to get enough people licensed where that will limit the number of people doing it illegally.
exactly.
Okay. I appreciate it. If you can see me on Zoom, you understand my questions,
Yes.
but I'm being funny. But anyway, you have a good day. Thank you very much. Thank you.
Thank you.
And we got the same questions, Delegate Aaron's. Delegate Fisher.
Thank you, Mr. Chairman. I just want to say this seems like a perfectly great bill. Makes common sense to me, and I'm hoping we can pass it this year. But I just want you to know that Delegate Aaron's was the lead on the floor of the House of Delegates for the hair braiding bill. So I do support him being the lead on this one as well.
I see where this is going. All right. Are there any additional questions? If not, thank you very much. And that concludes our hearing on House Bill 1317. What I'd like to do now is to take the next 2 bills together, House Bill 1199 and House Bill 1247. They are substantially the same. I took a look at the witness list. The witness lists are substantially the same. So as we call you up to testify, as we call the witnesses to testify, know that you're testifying on both bills. And so with that, I will start with Delegate Valderrama, and then we'll go to Delegate Washington.
Thank you, Mr. Chairman, and good afternoon, esteemed members and guests and witnesses joining us today here on Economic Matters Committee hearing. For the record, Chris Valderrama here to present House Bill 1199, Occupational Disease Presumption COVID-19. Let me just allow me to preface by saying I am no stranger to the workers' compensation arena, not an expert, not an attorney, but something I oversee. And having said that, as most of us here, whether you're in support or in opposition, presumption bills are a very big deal and a very heavy lift. But nonetheless, I understand, you know, the rationale and the need for this bill. I'm sure everyone does as well, and that's a just enough reason to submit such legislation. And I know it's been said repeatedly over many bills that have been introduced this year that deal with the pandemic, that it feels like a lot of these bills are simply for that. But prior to the pandemic and including, you know, other illnesses, again, if you just keep it up in mind, this is a just bill. So with that said, I appreciate your consideration. This legislation, House Bill 1199, creates a rebuttable presumption that an individual who is working at a job site other than in their home and who has contracted COVID-19 has done so at their workplace and is therefore entitled to workers' compensation. While the pandemic has forced many businesses to move employees to full-time teleworking, only 31% to 37% of all jobs can feasibly be performed remotely, according to an analysis from the US Department of Labor and the Bureau of Labor Statistics. So this leaves nearly 2/3 of all jobs having to be performed on site. Many of these employees, though not all, have significant exposure to COVID-19. Occupations like grocery clerks, transit workers, chicken and meat processors, farm workers, prison guards, teachers, firefighters, and other first responders are at greater risk for exposure to COVID-19, either because of their close proximity to those who are or may be ill, or because they work and live in close quarters, as is common among firefighters, ambulance squads, and farm workers. So what is a worker's redress if they become ill, needs to miss work, or God forbid, end up in a hospital because of COVID-19? Typically, workers who become ill or injured on the job might file a workers' compensation claim. But even before the pandemic, state workers' compensation systems were showing much strain. So set up over 100 years ago, workers' compensation systems are a grand bargain that are supposed to balance employer and employee rights. So employees give up their right to sue their employers over injuries and illnesses sustained on the job, even if they are caused by gross negligence. In return, workers are supposed to get speedy replacement pay and medical coverage, as well as survivors' benefits for their families, God forbid if they should die of their injuries. So over the last 20 years, though, workers' compensation benefits have diminished and criteria for coverage has become more stringent. One study showed that a mere 8% of injured workers ever file a workers' compensation claim because the process is so complicated. Most need to hire an attorney and sometimes medical experts, a strong disincentive, particularly for mid and low wage employees, as you may understand. Workers' compensation has always worked best when an employee is injured on the job in front of witnesses or when an illness is clearly attributable to a known carcinogen in the workplace. Few injured workers have such clear evidence to support their workers' compensation claim. But what about COVID-19? So what is an employee's remedy if he or she contracts COVID-19 at work? What if she works for a grossly negligent employer, one that provides no PPE, no social distancing, no hand washing facilities, and who allows employees to work on the premises when clearly ill with COVID-like symptoms? Now, I know there are folks on here who will say everyone's doing their business correctly, and I'm not saying they're not, but we all know there are some bad apples out there, just to emphasize. So if he or she contracts COVID-19, can that employee sue his or her employer for endangering their health? The answer is no. There is no private action against an employer, even in cases of gross negligence. The employee gave up that right in exchange for workers' compensation benefits. And while workers' compensation typically covers some respiratory occupational illnesses like tuberculosis contracted in hospitals or black lung from years of working in a coal mine, it doesn't cover airborne diseases like the flu or the common cold, but COVID-19 is not a common cold. So our workers' compensation system, as it is currently set up in our state, makes it nearly impossible for an employee to qualify for workers' compensation for COVID-19. And that's if the employee even bothers to try. So Chesapeake Employers Insurance Company their own numbers cited in the fiscal note makes this quite clear. To date, they have seen only 93 COVID-19 related workers' compensation claims in the entire state of Maryland. This in a state that has counted 383,000 COVID-19 cases with almost 8,000 deaths. Maryland law is particularly stringent in assigning employer responsibility. And in a case 2 years ago, in 2019, Baltimore County versus Quinlan, the Maryland Court of Appeals set out the standard for a successful workers' compensation claim. The claimant had to show that occupational disease was one, due to the nature of an employment in which hazards of the occupational disease exist, and two, it reasonably may be concluded that the occupational disease was incurred as a result of the employment of the covered employee. So employees in a few occupations that involve direct contact with COVID-19 patients, like first responders and some healthcare workers, might have an easier time making their case. One reason for this is because there are records that make these cases easier to contact trace. Yet, because community exposure is so great, will they be able to prove that their illness was actually caused by patient X, let's say? So certainly most other workers will never be able to prove exposure to COVID-19, particularly in occupations that are exposed to many unknown contacts. Will the grocery clerk ever be able to prove that their COVID-19 came from the 43rd customer that they served last week? Or will a bus driver ever prove his COVID-19 came from the coughing man who got on their bus last Friday? No, because there are no records of such contacts. So contact tracing for these exposed employees is impossible. So it's for this reason, HB 1199 seeks to change Maryland law by presuming workplace exposure was the source of COVID-19 unless an employer can prove otherwise through the same evidentiary means that all workers' compensation cases turn on. Moreover, I'd like to actually please note that this legislation is COVID-19 specific and does not affect workers' compensation cases for other diseases or illnesses. COVID-19 specific. The pandemic has brought workplace safety and disparities in workers' compensation coverage to the forefront in states across the country. Some 14 states, most recently across the bridge, Virginia, and the District of Columbia have created a workers' compensation presumption for COVID-19. Some of these actions have been in the form of legislation, and others are contained in executive actions. These states range from California, New Jersey, and Connecticut to more conservative states like Kentucky and Wyoming. Another 12 legislatures are currently debating similar action. Our workers here in Maryland deserve a workplace and deserve workplace protections against this disease. And so for all of I've said this afternoon, for all these reasons, I request a favorable report of House Bill 1199. Thank you, Mr. Chairman.
Delegate Washington.
Thank you, Mr. Chairman and members of the committee. Great to see you all again. For the record, Delegate Alonzo Washington here to present on House Bill 1247, or as I like to call it, the bill that Delegate Valderrama stole from me. No, it's a great bill. The differences between, I'm going to be very short, Mr. Chairman, because I think the delegate did a fantastic job explaining my bill and her bill. And the differences are that my particular bill focuses on fire public safety officials. And I urge a favorable report for those reasons and all of the reasons that Delegate Valderrama has stated. Thank you, Mr. Chairman.
Thank you. We're about to go to the witness list as soon as we get our clock adjusted. So if my clock manager can adjust the timer, we can get started with Rose Wirtz.
Chairman Davis, did you want it on 2 or 3 minutes? I was told
2.
For 2. Okay.
Yes. Rose Wirtz.
Good morning, good afternoon, Chair Davis and members of the House Economics Matters Committee. I'm Rosemary Wirtz, Field Coordinator for AFT Healthcare Maryland. We're the labor union representing healthcare professionals in state government. We thank you for the opportunity to just speak in support of House Bill 1199. Our members, we represent state employees. As I said, many of them have been reassigned to duties related to COVID-19 response. We have Office of Healthcare Quality nurse surveyors that have been assigned to the strike teams that are sent into long-term care facilities with COVID outbreaks. We have nurses conducting testing, administering COVID vaccines, taking temperatures as part of the screening process. Our members include doctors, nurses, and other health professionals working in residential healthcare facilities in Maryland, as well as juvenile detention facilities. These state employees, your employees, have taken on all of these new responsibilities and tasks as asked. They have been working massive amounts of overtime. They've canceled vacations. They've taken on all these additional duties that are so vital to the state's pandemic response. But in doing so, they're risking additional exposure to the virus. As you know, since the beginning of the pandemic, and Delegate Valderrama touched on this is a very unique situation because of the contact tracing. Now, we represent state employees, and those employees work primarily for the Maryland State Health Department. That's the department that's assigned to do the contact tracing. Let me just give you an example of the proof that's out there for our members. So when an individual tests positive to COVID-19, they go into the contact tracing process, and some of our nurses are engaged in that process, so we know a little bit about it. So an individual is interviewed and then it spreads from there. Management has all of the information from contact tracing, and we have asked repeatedly at multiple facilities for information with regard to contact tracing, and management says we can't have it because it's HIPAA violation. We can't prove that an employee was exposed at work if we can't have access to the information necessary to meet that burden. So we're asking for the burden to shift to management, because management, in our case, management has all the necessary evidence to prove whether or not an employee was exposed 14 days prior to their positive test. So if
Words,
one of our nurses,
Ms. Wertz, your time is
yes. Oh, I'm sorry. We're asking for a favorable report for House Bill 1199. Thank you very much.
Thank you. Donna Edwards.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. The sponsor did a fantastic job of laying this bill out, and all of that is behind it. COVID-19 negatively impacted every family in Maryland and around, and all of us have seen the effects economically and in healthcare, and many of us have lost our loved ones, friends, or neighbors to COVID-19. There's a lot of conversations in the policy circles focused on how to return to normal. And many of our friends and family do not have the luxury of returning to a new normal because they've been working hard every day and in exposing themselves to COVID-19 and exposing their families to it. So it's imperative that we do everything that we can to provide the support. We talk about our first responders and our frontline healthcare, but we also need to talk about those essential workers that gave all of us a feeling of normalcy when we were, held up in our houses. We went to the stores, we went to the grocery, we saw the buses, we saw the postal workers, we saw everybody keeping our life in some sort of normal. So in short, we must protect our essential workers. The sponsor already said this is not a new idea to Maryland. The concept is not new to Maryland. There's at least 17 states and Puerto Rico that have extended workers' compensation coverage to include COVID-19 and presumption. There are other states considering it as we are talking here. So failure to take the action of COVID-19 into workers' comp is probably going to extend itself into higher healthcare costs for all taxpayers. So COVID-19 is a workplace-related injury for many workers in our state, and it should be treated as such. And we desperately urge for a favorable report for HB 1199. And I did it in 2 minutes, Mr. Chair.
Very nice. Very nice. Daniel Udoff.
Good afternoon. For the record, my name is Daniel Udoff. I'm an attorney with the law firm Conn Smith & Collins. I want to express my thanks to the chairman and members of the committee for your time and consideration with regards to the bill, which it is my privilege to support today. The benefits available through our workers' compensation system are absolutely essential. Lost wages, medical treatment, vocational rehabilitation, and awards for permanent disabilities fill the gaps which are often left by other forms of state and federal disability laws. Certain occupational disease claims sometimes require modification of our statutes to ensure that their protections are appropriately utilized. These circumstances apply specifically where it may not be possible to determine absolute causation between a workplace and a disease. Common sense, however, and general knowledge must be factored into the legal analysis in these circumstances. This is the notion which gives rise to the necessity behind legal presumptions. As already stated, presumptions are not a new concept to our workers' compensation system and have been successfully implemented for years with regards to, for example, police officers and firefighters. And they by no means place an undue burden on employers or insurers. These are not strict liability statutes. They do not prohibit employers from defending against these claims. And furthermore, they do not in any way alleviate claimants of their evidentiary obligations. They still require supportive medical documentation and expert causal relation opinions to bring a successful occupational disease claim, even with the existence of a presumption. This pandemic is a textbook example of the need for a legal presumption as it pertains to frontline and essential workers. These workers in many ways serve as the backbone for both our society and our economy, and the inherent nature of their employment makes it impossible to exercise precautions which have been so clearly enumerated by health experts and the CDC. We are all aware of the added risks and exposures undertaken by these individuals on a daily basis. Justice requires that the laws which exist for their protection be correlated to the additional hazards which they face as necessary consequences of their employment. Thank you for taking the time to listen to my testimony this afternoon and for your consideration of this critical issue.
Thank you. Antoinette Ryan Johnson.
Good afternoon, Mr. Chair and the Economics
Good
Matters.
afternoon.
My name is Antoinette Ryan Johnson, and I am the president of the City Union of Baltimore. The members of the City Union of Baltimore are employees of various agencies, including the Baltimore City School System, the Department of Transportation, the Baltimore City Health Department, Department of Public Works, Fire and the Police Departments, amongst others. I call on this committee to give a favorable report to House Bill 1199. I believe you have my written testimony, so allow me to make some brief remarks. Our union consists of numerous essential employees that provide vital services to the residents of Baltimore City and surrounding jurisdictions. Many of these workers have underlying health conditions or live with family members who have pre-existing conditions that make exposure to COVID-19 more dangerous. Numerous of our members have contracted COVID-19 while at work. Some are seriously ill, others are in the hospital, and we've had several deaths. Workers risk their lives and health to keep us all safe and healthy. Should not have an added burden of worrying about how to put food on the table and keep a roof over their heads if they are out of work for an extended period of time. Members of this committee, we ask those essential employees to be on the front lines for us during this fight against COVID, being physically present at work Being physically present at work means that their services keeps a sense of continuity of our government. We cannot ask them to also have to fight their employers and the corporate insurance companies to prove their workman's comp claims at the same time. Stop asking them to fight two wars against this pandemic. We owe our essential employees so much for what they have done for us. We should not add burden to those who contract COVID at work. I ask for a favorable report of House Bill 1199. Thank you.
Thank you. Matthew Engler.
Good afternoon, Chairman and committee members. Thank you for the opportunity to speak in support of these COVID-19 presumption bills. For the record, my name is Matthew Engler. I'm an attorney at the law firm of Berman, Sobin, Gross, Feldman, and Darby. And I've had the great privilege of representing many of our frontline essential workers, including first responders, healthcare workers, and many other occupations who have been directly affected by this pandemic disease. It's with this background that I'm speaking to you today in support of both House Bill 1247 as well as House Bill 1199. Those separate bills, I will just in a moment speak a little bit about that. I want to address why they're a crucial need. First off, our essential first responders have worked tirelessly over this past year to maintain the same, if not higher, levels of professionalism and service, despite the unusual and far too often tragic circumstances that we've been living through. And they did this all without any risk, while taking on the risk, their own health and well-being. As an attorney representing some of these first responders and essential workers across various employers and jurisdictions, one of the things that has struck me in working through these claims is that the different treatment they get depending on the employer. While in some jurisdictions, an exposure to a coworker at work will be readily accepted and the workers' compensation benefits provided in a neighboring jurisdiction doing the exact same thing with a nearly identical fact pattern, the claim will be contested and we'll have to go to a hearing before the Maryland Workers' Compensation Commission. It's because of what I believe is the inherent unfairness of this disparate treatment, just depending on which municipality you work for, that it's imperative that we ensure that there is a universal standard across the entire state for our first responders, our firefighters, our EMTs, our police officers, and other essential workers. We cannot, as was just stated by the witness just speaking before me, have them be concerned with the burdens of this. So I ask for a favorable report for both the House Bill 1247 and House Bill 1199. Thank you very much for your time.
Thank you. Patrick McAndrew.
Good afternoon, Mr. Chairman, Vice Chair Dumais, members of the committee. It's my pleasure to be here this afternoon to speak to you in support of House Bill 1247 as well as House Bill 1199. First, though, I would like to thank my home delegate, Delegate Alonzo Washington, for sponsoring House Bill 1247. This is a very important piece of legislation, as all the other speakers have already pointed out. Firefighters, EMS personnel, law enforcement officers, they don't get to choose which calls they respond to handle, whether it's a traffic accident, an medical emergency, or a family disturbance. The risk of exposure to the coronavirus is very high. As Mr. Engler said, while each employer and insurer treat current COVID cases differently, allowing for this presumption in the statute will bring statewide uniformity to those that are exposed. And as one of the other speakers said, this is a presumption only. This presumption can be overcome by the employer with competent evidence. What we're seeing across the workplace, but specifically within law enforcement, is the threat to the personal safety of public safety personnel is very real. As of March 1st, based on data collected by the National Fraternal Order of Police, 437 law enforcement officers across this country have died from COVID-19. 6 of those officers in Maryland. Untold numbers of fire, EMS, and corrections personnel are similarly affected. I would say our first responders have been there for us during this pandemic. They certainly need our support now, and I respectfully ask that you report out favorably both House Bill 1247 and House Bill 1199. I thank you for the opportunity to appear here this afternoon. Good afternoon.
You were muted, Mr. Chairman.
Lance Kilpatrick.
Thank you, Chair Davis and members of the Economic Matters Committee. For the record, my name is Lance Kilpatrick, and I'm the Legislative and Political Director of AFSCME Council 3, representing 30,000 state and higher education employees in Maryland. We've never dealt with a challenge like COVID-19 before. Frontline employees across Maryland have fearlessly continued reporting to work, even through shortages of PPE and information. They heard the call and responded to the challenge, but they've done this while having to surmount seemingly endless obstacles put before us. A lack of PPE, a fight still ongoing over getting N95 masks to our members and appropriate gowns for those in closest contact of the virus, a lack of planning and safety protocols that have led to wildly divergent responses to outbreaks from facility to facility and campus to campus. Our neighbor to the south, Virginia, became the first state in the nation to establish detailed coronavirus-related safety mandates that all companies under the jurisdiction of VASH must abide by. MOSH has not. And I would be remiss if I didn't point out that Maryland's chronic understaffing of its facilities made a bad situation worse. All of this has come with a horrible cost. Thousands of state employees have contracted the virus while continuing to serve Marylanders. AFSCME Council 3 applauds Delegate Valderrama and the other General Assembly members who have championed workers' compensation eligibility for those stricken by the pandemic. The long-term effects of COVID-19 are still being discovered. And while we are still learning of these effects, we know that a fair and equitable starting point for presumption of workers' compensation eligibility should be the date of the declared emergency, March 5th, 2020. We respectfully request that the bill be amended to retroactively apply to that date. We thank you and strongly urge a favorable report of HB 1199 with amendment. Thank you.
James McAllister.
Mr. Chairman, can you hear me?
Yes, sir.
Okay. Mr. Chairman, members of the committee, thank you for bringing this bill forward. Maryland currently has presumptions in workers' compensation for public safety workers because they're the people that run towards what the rest of us run away from. So we say, look, if something happens to you, we're going to make it easier for you to prove your claim. Well, these bills speak to the people who ran towards what the rest of us ran away from, those of us who could work remotely, those of us who had the luxury of phoning it in. These people didn't have the luxury of phoning it in. The police, the fire, the frontline health workers, the cashiers, and by the way, the bus drivers who faithfully worked every single route and got those people to work deserve the same protections that the public safety do. And let's talk about teachers. As a guy who has 2 adopted foster kids in a 3-bedroom, 1-bathroom row home in Arbutus, there's nobody that says the school reopening prayer more often than me and my wife. But let's tell the teachers, listen, if you go back to work and you get sick, you're covered. Because sending the kids back in there is one thing, but telling the teachers that we trust them and we value their service and the risk they take, that if they get sick, they're covered. They're not going to have to use their leave. Their medical bills will be paid. There'll be no deductibles. And in the event they're sickened so badly, they can't go back to work, there's going to be workers' compensation that will find them comparable employment. How could we tell our teachers with a greater persuasive message to go back to work than to trust them, to trust us to give them the benefits? The other thing I want to talk about is unpaid medical bills. There's this theory that somehow unpaid medical bills just go away. Health insurance has paid these bills. Medical assistance has paid these bills. Medicare has paid these bills. Hospitals have all sorts of bills that haven't been paid. Those aren't going anywhere. So if we don't have a presumption bill that helps get those paid on behalf of the employees who incurred them when they got sick at work, we're going to see those bills again in the form of rate increases or higher hospital bills because they raise the price to recover the uncompensated care. The MAJ favors this bill with some amendments. We think it's a great bill, and it's time to recognize the sacrifice of those who've gone to work during a pandemic. Thank you.
James Lanier.
Good afternoon, Mr. Chairman and members of the Economic Matters Committee. My name is James Lanier, and I'm here on behalf of the Maryland Association for Justice, as Mr. McAllister is as well. We've had a bunch of witnesses. I don't want to restate everything, but I do want to focus on a few small issues. One, the gentleman from ASME mentioned is the retroactivity. As both bills are currently drafted, they would be enacted, they would come into effect upon enactment. But the damage that many Maryland workers have already sustained has already occurred. And as the gentleman indicated, from the March 1st, 2020, if the bills would be retroactive to those dates, they would be more impactful, because even if the fiscal and policy notes indicated, the first time in which the coronavirus was detected in Maryland was on March 3rd. So if we go back to March 1st, then we're going to cover all of the workers who could have been affected by this at the work, and the presumption, the rebuttable presumption, would affect and help them get the benefits that they so desperately deserve. In addition, with regard to who is covered, there are slight discrepancies. For example, HB 1249 with respect to Delegate Washington, correctional officers are not covered by it. So the Maryland Association for Justice supports both bills with amendments. So we're requesting a favorable report with amendments to make sure that all public safety members that are already recognized by the Maryland Workers' Compensation Act are covered, but also as for the retroactivity of the enactment being back to March 1st, 2020. So with that, we are requesting, again, a favorable report with amendments. Thank you very much for your time.
Cheryl Bost.
Cheryl Boast, but that's okay. It's a 50-50 shot.
Good afternoon, Chairman Davis and Vice Chair DeMay and members of the committee. My name is Cheryl Bost, and I'm an educator from Baltimore County, serving as MSCA president, representing over 76,000 educators across the state. I first want to take this opportunity to thank so many of you for committing and recommitting to the students and educators of this state by enacting the blueprint for Maryland's future. We truly do thank you, and it's an investment in our students. The Maryland State Education Association supports House Bill 1199 for the various reasons that the sponsor and many of my union brothers and sisters have already shared. We also respectfully ask that you consider a retroactivity so that this bill would start March 5th when the state of emergency was enacted. As you know, on March 13th, school buildings closed, but learning and working did not. Our food service providers served millions of meals. Our custodians were in there, our secretaries, and so many of our educators also were in and out of the buildings. This passage of this bill would also provide an incentive for school systems and other employers to implement reopening health and safety protocols with fidelity. While educators have been told they would be provided with adequate PPE and that schools would have thorough health and safety procedures, that is not what we're seeing across the state. So this adds another layer of accountability that those protections will be put in place. And remember that we represent not only our teachers, but custodial staff, technology assistants, food and nutrition workers, administrators, just to name the few. Many of our frontline workers who've been working since day one of the pandemic. So we urge a favorable report with retroactivity on House Bill 1199. Thank you and have a great day.
Thank you. Jeffrey Buttle.
Good afternoon, Mr. Chairman. Jeff Buttle, President of the Professional Firefighters of Maryland. We represent over 10,000 active and retired firefighters and paramedics across the state of Maryland. For the record, on the bills, we are favorable on House Bill 1247, which is Delegate Washington's bill. And overall, we're favorable on House Bill 1199 as well, with one amendment that we want to be able to work with the subcommittee and committee on, and that's on page 6 of the bill, lines 2 through 4, where it deals with rebuttability of the presumption. We believe as it pertains to firefighters and paramedics across the state, it's not necessary to include an additional definition of rebuttability on a presumption. This was done by the Maryland Court of Appeals in the city of Frederick versus Schenkel, which is from 2001. It is 20 years of standing case law that has protected firefighters and paramedics and defied the parameters of the rebuttable presumption. And we want to make sure that moving forward, we continue to follow the 20-year case law as associated with firefighters and paramedics, and don't get that mixed up with any other definitions that we might apply to other professions or other career fields, because it's very specific to our profession. So with that, Mr. Chairman, I thank you for your time, and we are favorable with amendments on 1199 and favorable on 1247. Thank you.
Thank you, sir. Any questions for the proponents of the bill? If not, let me go to Louis Campion. Are you there, Louis? If not, I'll go to Christopher Costello and then Michael Daly.
Please hold my calls.
Would be happy to.
Mr. Chairman, can you hear and see me?
Yes, we can.
Okay, well, I hope I look okay. Good afternoon.
You're all right.
Committee Chair Davis and Vice Chair DeMay, members of the Economic Matters Committee. Chris Costello, I'm representing the Howard County Chamber of Commerce, 700 member organization that includes large corporations, small businesses, nonprofits, and government agencies in the greater Howard County business community. Our mission of the Howard County Chamber is to provide advocacy and access to a timely information that supports economic growth and stability in the greater Howard County business community. Now, the members of Howard County Chamber certainly understand that the sponsors of this legislation put this bill forward out of concern for Marylanders who have been exposed to COVID-19 and may be out of work and may not have adequate health insurance and many other problems. And while our members sympathize with these concerns and are doing a great many things to assist their employees in this regard, they disagree that the way of addressing these concerns should be to amend the employer's workers' compensation insurance policies. The Howard County Chamber reached this decision to oppose these bills out of concern for the unwarranted administrative and legal difficulties that this legislation would create for all employers in both the public, private, and private sector, both by assigning an occupational disease status to an infectious disease, which is an unusual thing to begin with, and that can be transmitted via multiple possible encounters in the community, and by creating a presumption that this condition would be compensable for workers' compensation. And the only defense available for the employer would be to prove beyond some plausible doubt that the employee was exposed outside the workplace. This is something that is, you do see presumptions. You only see them in the public sector, and usually it's for first responders, certain law enforcement, and firemen, such as that. There's no presumptions on workers' comp, occupational disease in the private sector that I know of. And all those presumptions, I said, are for certain occupational disease, for such things as exposure to toxic substances that might cause cancer, high risk, high stress jobs such as police, firemen. And this bill also includes all essential workers, not just public safety or healthcare workers. The current presumption in the section, as we mentioned, well, I mentioned all that. Let me run on.
Chris, your time has expired.
Okay, well, let me just end it up by saying that we think that COVID-19 is, if this bill is just intended for that, we're soon going to see an end to this, and so we think that this bill is inappropriate. This is a private insurance. It's not a public or social program. It's really a private insurance, and we think that it's an inappropriate thing to try and build a social concerns on. So we would ask for an unfavorable decision. Thank you.
Thank you. Michael Daly.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Michael Daly. I am the legislative co-chair of the Maryland Defense Council, and I am an attorney practicing workers' compensation representing employers and insurers. Let me start by saying that we concur and understand that the proponents to this bill come from a place of concern. However, we think their concerns are misplaced, and let me start with the procedural part of this. They're asking that the current statutory section 9-503, which is limited now to public safety folks and in occupational disease settings, that there are presumptions in limited diseases associated with exposure over time. Occupational disease in Maryland are specifically found by our courts to be diseases that occur over a long extended period of time. In this case, the commission has already correctly adjudicated these cases when necessary to find that they're accidental injury exposures, not occupational diseases. So this statutory amendment creates potentially unforeseen problems that we've talked about in presumptions in general over the years anyway. So that's concern number one from the MDC. The other part of the problems with this is that the alleged rebuttable potential just simply doesn't exist in this case. The standard that is laid out, especially in 1199, simply is one that just says that you've got essentially the employer is going to be presumed to have caused the exposure at work unless there is some way to show that it was in no way a contributing factor. And clearly that's not a rebuttable standard that could ever be met. For these reasons, we are asking for an unfavorable report. Thank you for your time.
Thank you, sir. Pilar Clemens.
Good afternoon, Chairman Davis. Can you see me and hear me?
I can hear you. I'm not sure that I can see you. There you go.
Am I on? Am I there?
Yep.
All right, thank you. Good afternoon, Chairman and Vice Chair and committee members. My name is Pilar Clemens. I'm the Director of Government Relations at Chesapeake Employers Insurance Company. Chesapeake does oppose the presumption for COVID in Maryland. However, that's not to say we aren't aware of the difficult year and the effects COVID has had on all Marylanders. These bills attempt to solve a problem that we haven't seen yet exist. Employees can currently file workers' comp claims for COVID-related claims and do and have received benefits. Chesapeake has had 787 first reports of injury, and only 70 have been denied or disallowed. As of March 1st, we had 103 claims filed, 51 were accepted, 16 are awaiting hearing, and 26 are still being investigated. The Workers' Compensation Commission reports they've had 1,190 COVID-related cases to date. By contrast, the Maryland Department of Health reports about 383,000 confirmed cases. House Bill 1199 includes all public safety as well as childcare workers, healthcare workers, essential workers, and education workers. The application of this bill would increase costs for the state and local governments as well as the private sector and small business by an indeterminate amount, and as indicated by the fiscal note, potentially significantly so. Applying a presumption to COVID as contemplated in these bills would deviate substantially from current Maryland law. I won't reiterate what Mr. Daly has said, but specifically, we've never had presumptions for anyone other than public safety. We've never had presumptions afforded to a condition where the disease has an exact cause that can be traced. Excuse me. For example, if a firefighter works for 20 years, has a family history of lung disease, and smokes for 20 years, it's difficult to tell which smoke caused the cancer. The presumption in that instance switches the burden from the claimant to the employer to give the claimant the benefit there. In the case of COVID, we can trace, and we have successfully been able to contact trace in a lot of these cases where the COVID's coming from. So I say that to say the system is working. Chesapeake urges this committee not to take drastic and unprecedented measures with this bill, as the system is already able to provide benefits when appropriate. Thank you, and I'll yield my lack of time back. Thank you.
Thank you. Drew Jabin.
Hello. Thank you, Chair, Vice Chair, members of the committee. For the record, Drew Jabin on behalf of the Maryland Association of Counties, here respectfully in opposition to House Bill 1199 and House Bill 1247. As always, you have my written testimony. I will be brief. You've already heard from many witnesses making the same points as I would like to make, just a few more. These bills would dramatically expand the scope of presumption for workers' comp, therefore placing significant costs on local jurisdictions. As noted in both of the fiscal notes, counties employ quite a large number of essential workers that are included in both bills, meaning that there will be, again, major fiscal impacts. Under these bills, there would be a nearly irrebuttable presumption that any affected worker should be compensated by the employer, even if there's no supporting evidence for an actual workplace exposure that caused the illness. Even if the claimant is out grocery shopping, attending social gatherings, eating in restaurants, or engaging in potentially risky behavior such as not wearing a mask, not social distancing, traveling, the employer still would be responsible. It doesn't even matter if the employer could trace this diagnosis back to a family member, strict liability is applied to the employer. Additionally, just one more point, House Bill 1247 does not seem to differentiate between a front-facing employee and another employee who may have a member of the public walk by their workstation, which increases the pool of eligible employees able to claim workers' comp by a significant amount. Both of these bills would create new unbalanced laws and have a significant effect on county government finances. So accordingly, MACO requests an unfavorable report on both House Bill 1199 and 1247. Thank you.
Robert Erlinson.
He's muted.
Can you hear me now?
Yes.
Okay, very good. Thank you. And just want to start off by saying, Delegate Valderrama, you do yourself a great injustice. You've really stepped up in terms of helping everybody in terms of understanding workers' compensation law and the tradition of Sally Jamison and kind of Mike Bush, who I think we all remember very fondly. I'll just simply adopt the arguments that were made in the written the report that I've submitted to you all, and just want to make one or two quick points. First of all, the burden that is put on the employer with respect to 1199 is, at least in my view, unclear. It talks about the employer have to show that employment was not a, quote, contributing cause to of the disease. That term is not defined. You will note that in other sections of the statute, such as, for example, intoxication, they use the term primary cause as a defense to a claim by way of intoxication. That term is defined. It is not defined, contributing cause is not defined in this statute. So it's unclear what exactly the employer is to establish. And it also doesn't establish what is the level of the burden of proof. There are various levels of proof. I kind of think it's due to employment. I'm pretty sure it's due to employment. There's beyond a doubt, no doubt about it, it's due to employment. This statute does not outline exactly what that is. So for those reasons, as well as the reasons presented by other speakers, I would respectfully ask for an unfavorable report. Thank you, Mr. Chairman.
Thank you, sir. Nancy Egan.
Good afternoon, Chair Davis, Vice Chair Dumais, and other distinguished members of the House Economic Matters Committee. I have submitted a written testimony on both bills in opposition, and I will not review what you've already heard from the people that testified before me. I just want to focus in on just 2 points. One of them is in the bill itself. It's talking about the proof of the disease. Currently as the way it is drafted, it appears that the presumption for warranting coverage is inadequate because it just requires a mere diagnosis without a test, a positive result of an undefined test, or a positive result on mere antibody test. This should be defined as a positive PCR test for COVID-19, an incubation period consistent with COVID-19, and symptoms and signs of COVID-19 that require medical treatment. In my testimony, there's some information about what a PCR test is. It's both approved by the Infectious Disease Society of America and the Council of State and Territory Epidemiologists as well. And as you've already heard, antibody tests can be providing false negative results. So this is one of the reasons why it should not be used. One other thing that I would like to talk, if this bill should move forward, or either one of the bills, there should be a specific defined end to the date of such a presumption. As more and more of the people of Maryland become vaccinated and we get to the point that the state of emergency should end, the presumption itself should also end when the emergency order ends. And with that, we are here to answer any questions and hope to work with the committee on this bill and 1247 as well. Thank you.
Thank you. Bill Kress.
Thank you, Mr. Chairman, members of the committee. Bill Kress here today on behalf of the Maryland Association of Boards of Education Workers' Compensation Self-Insurance Fund, which is a workers' compensation fund consisting of 17 school boards in opposition to the bill. And I think the witnesses prior to me covered many of the reasons. I just want to go back and hit 2 quick points. I think Mr. Daly hit it on the head. COVID claims are accidental injury claims. There is really no need to shoehorn this into occupational disease, and certainly no need to make it a presumption. What we see from the data from the claims is many of these claims are being accepted, and they're being accepted as accidental injury claims. So we think there's no need for the bill in that standpoint. But just to be clear, if you make it a presumption and apply it broadly to all these employment categories, you will have a situation where employers are going to be paying for every single COVID diagnosis, simply because the presumption, the rebuttable presumption standard, in particular in 1199, is just unworkable. There's no way that an employer is going to overcome that presumption. And we certainly sympathize with all the employees that have contracted COVID. We think there's a reasonable method for getting a compensable claim found. We think that the commission is doing that now, and we would urge the committee to issue an unfavorable report. Thank you.
Thank you. Final witness on this bill, Julie Murray.
Thank you. Good afternoon, Chairman and members of the committee. Julie Murray here, also on behalf of the Maryland Defense Council. To sum up some of what we're looking at when we've been looking at this bill and why we were so opposed is mostly because this bill addresses a problem that, frankly speaking, we think does not exist. COVID claims have been filed with the commission. The ones that should be found compensable are being found compensable through the ordinary statute, and the Workers' Compensation Commission is adjudicating those claims in a timely fashion. There has been no delay in receipt of benefits. Most, if not all, employers are offering initial salary continuation benefits to employees who require quarantining as a result of a COVID-19 diagnosis. And most, if not all, employers also afford health insurance coverage to their employees. I would also just like to point out that the other problem MDC has with the presumption is the real lack of a specific scientific basis for this presumption. We're concerned that the expansion of the presumptions that have been previously established for specific types of cancers and occupational diseases for first responders, that by expanding this, it could wreak immeasurable havoc on the private and public sector. Lastly, I would just point out that almost all, if not all, of the other states that have enacted some type of COVID-19 presumption legislation have done so either without a retroactivity provision and with a very distinct sunset. The two bills that have been proposed here are essentially an open-ended invitation to continue to lodge claims for a disease that hopefully we are going to see an end to over the next few months with the onset of the vaccine. So for all of those reasons, I join in what everybody else has already said, and we would ask for an unfavorable report on House Bills 1199 and 1247. Thank you.
Delegate Valderrama.
Thank you, Mr. Chairman. It's more commentary than questions, but point of personal privilege being the sponsor as well as Delegate Washington. I just wanted to make a few points, and I also prefaced before my testimony that everyone here, whether in support or opposition, but especially those in opposition, I totally understand your point of view, and many of you I have had conversations with over workers' comp. So I'm very familiar from where you're coming from. And again, I explained the introduction of this bill and why, and you know all of that. So with that said, with utmost respect, I just wanted to point out certain, Mr. Costello, you mentioned that there was no precedent, that there's only, this is usually only in the private sector, and it doesn't seem warranted. And I understand where you're coming from, but I also just want to say, just because there's no precedence, you know, COVID doesn't decide who gets it, right? So workers who've been out there on the front lines for us, whether they're private or public, COVID does not distinguish between the two. I just wanted to point that out, and I'm sure that you know that as well. I just wanted to make my point. And then there were a couple comments, Mr. Daly and Pilar, love you guys, I totally get it. But comments were made, you know, that this hasn't been done before, but we haven't had a pandemic before either. So again, I'm sure we all understand why certain bills are being introduced. And Miss, is it Jabin from MACO? You mentioned, and I was trying to write this all down as fast as I could, that even though you mentioned something about the employee doesn't even have to show evidence, but I was pretty sure I was clear, and in case I wasn't, but again, not the attorney, I'm not the attorney, but the bill does say, as long as the employer can rebut that with evidence. So I know you say claims are being made and some are being approved and not, but again, just wanted to make a point. And Miss Egan, also great relationship. You mentioned that maybe if this were to go, that an amendment, a presumption ends when the pandemic ends. I understand where you're coming from on that, but also COVID doesn't just go away. And, unfortunately, there are some employers, hopefully it goes away, but the folks who are trying to claim these benefits sometimes will be stuck with that situation, whether it's after effects of COVID or not. And then with that, I just wanted to make those points. And Mr. Erlinson, you were very kind with your words, but in no way am I Sally Jameson or the late Speaker Bush, just trying to learn from the great mentors.
Yeah.
Having said that, thank you, Mr. Chairman, for your lineage. Yeah.
Anyone else? If not, that concludes the hearings for House Bill 1199 and House Bill 1247. So let's go to Delegate Carey and House Bill 909.
Thank you, Mr. Chairman. Good afternoon. This is a tough bill to follow, so bear with me. I have my panel here, Mr. Chairman, Mr. John Willems from the Maryland Association of Boards of Education. And I'd just like to say good afternoon to you, to Vice Chairman Dumais and the members of the committee. Thank you for the opportunity to introduce House Bill 909. This bill would exempt our local school systems from the requirement to provide a sick leave to substitute employees. When the General Assembly passed this law, it included an exemption for employees who work on an as-needed basis in the health and human services industry. This bill corrects an oversight in the paid sick leave law by enacting a similar exemption for substitute employees of our local school systems. The current requirement to provide paid sick leave is seen as an unfunded mandate by our local school systems, and the requirement has generated a significant cost as our schools are effectively being required to hire substitutes for substitutes. For some school systems, the savings could be substantial, and I would point out that in my county, Anne Arundel, it would save over $500,000 a year. So at this time, when all of us are focused on the amount of money that our local school systems receive, I believe that this funding would be better spent on other educational needs. Therefore, I respectfully request a favorable report on House Bill 909. Thank you.
Thank you. John Willems.
Mr. Chairman, members of the committee, John Willems representing the Maryland Association of Boards of Education. I want to thank Delegate Carey for sponsoring this legislation and urge the committee's favorable consideration of what we consider to be a common sense, modest but meaningful request to incorporate our daily substitute on-call as needed employees into the statute that has provided an exemption for such employees in the broadest sense for the health and human services industry since the legislation was enacted. I want to stress how much we value the service, the role of our daily substitute employees, but that the discretion they have to accept or reject the offer for employment that day is essentially what is at the heart of this legislation with regard to the work that is involved in monitoring, maintaining, tracking the accrual of earned sick leave for employees who are essentially only called upon to fill in for employees who may themselves be essentially out sick. And so there's really no rationale. It's rather perplexing, a little counterintuitive to cover these daily on-call substitute employees in the statute. There is language in the statute now. There was an understanding that it would apply to us. There are other provisions of the law as well that limit the number of hours that you work within a pay period and whatnot. I think there may have been the perception that our daily subs would fall under existing exemptions within the statute, but that's not the case. This has been a heavy lift for us over the last couple of years, and we're seeking the legislation to relieve us of the obligation to essentially accrue and compensate our daily substitute teachers for the earned sick leave benefit under the statute. And for those reasons, we urge a favorable report on House Bill 909. Thank you.
Any questions of the sponsor or his panel? Seeing none, Tyra Robinson.
Yes, good afternoon, Chair Davis, Vice Chair Dumais, and members of the committee. Thank you for the opportunity to testify today. My name is Tyra Robinson. I'm an attorney at the Public Justice Center and the Workplace Justice Project. We're a nonprofit civil justice legal organization, and the Workplace Justice Project enforces and expands the right of low-wage workers through policy advocacy and litigation. The PJC opposes HB 909 and requests an unfavorable report for a few reasons. First, HB 909 undermines the purpose of the Healthy Working Families Act, which ensures that employees don't have to choose between a paycheck and caring for themselves or a family member. It's also designed to limit presenteeism, where individuals who cannot afford to take time off show up for work ill, are less productive, and spread illness to coworkers. This is particularly a problem in situations where employees interface with the public, such as in school systems. Substitutes also work in classrooms, nurses' office, drive school buses, and clean our schools both during and at the end of the day. And like anyone, substitutes get sick too. Maryland shouldn't adopt policies that force any in-school employees, regular or substitute, to show up for work sick. Second, this bill is unnecessary because one of the compromises in the passage of this law included a provision that exempts any employee who regularly works less than 12 hours a week for an employer. And this includes individuals who generally only work 1 or 2 days a week. They would not be covered by the current sick leave law. An Attorney General opinion in 2018 addresses this issue. Exempting more workers from Maryland's sick leave law is unnecessary and unsafe during a pandemic. Finally, cost should not outweigh public health. A motivating concern between this bill seems to be cost of school systems, but cost alone is not a reason to deny the ability of substitute school employees to earn sick leave given the public health implications. Earlier data demonstrates that leave that was actually paid out for sick leave was not accurate to doomsday predictions and revealed that jurisdictions incurred little or no fiscal impact in providing required leave. For these reasons, I urge an unfavorable report on HB 909. Thank you.
Thank you. Corey Johnson.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the House Economic Matters Committee. For the record, my name is Corey Johnson, and I'm an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force. At JOTF, we are committed to increasing policies to allow for meaningful access to job opportunities for low-skill, low-wage workers and eliminating barriers to meaningful employment. We oppose House Bill 909 as a means of ensuring that hardworking Marylanders can continue to access our paid sick and safe leave without having to risk their job, paycheck, or financial security. In February 2018, 70,000 Marylanders began to accrue earned sick and safe leave under the Maryland Healthy Working Families Act. After working with a plethora of partners for 6 long years, we finally secured a solution that the committee, as well as the general legislature, was satisfied with. As you know, with the impact of the COVID-19 pandemic, now more than ever, individuals need access to their earned sick leave. I would like the committee to keep in mind that this leave is a right and not given. What we have seen in regards to the pandemic is that no one is safe from illness. More particularly, working families are the most vulnerable. The Maryland Department of Health reported that there have been 382,000 confirmed cases of the virus in the state of Maryland, and 697 Marylanders have died. The COVID-19 pandemic has demonstrated that no one is free from its grip, no matter the individual's employment industry. HB 909 seeks to exempt from the Maryland Healthy Working Families Act employees of a county board of education who are called to work on an as-needed basis. This includes individuals such as substitute teachers who are putting their health, wellness, and safety on the line to provide Tier 1 education to our students. As many Maryland schools have begun reopening procedures and are back at operational capacity, these individuals should have access to their earned sick and safe leave, not only to protect themselves and their families, but students. Sick teachers should not be forced to choose between their employment and exposing students to a deadly virus. For those reasons, we urge an unfavorable report.
Are there any questions? Seeing none. That concludes our hearing on House Bill 909. I'd now like to go to House Bill 841, Delegate Otto.
Thank you, Mr. Chairman, Madam Vice Chairman, my good friends on the Economic Matters Committee. Thank you for this opportunity to come to you without a liquor bill that I usually end up doing for my counties. I am Charles Otto, representing Somerset and Worcester County, District 38A. What we have today is House Bill 841. I'd like to introduce to you. It's a cross file with Senate Bill 502. It's a bill that deals with farm workers and those working at farm stands and farmers markets, that dealing with the exemptions that are allowed from the minimum wage legislation. These are exemptions. The bill clarifies who's what workers are qualified for that exemption. It'll impact mainly the farm markets that you see along Route 50 on the way to Ocean City and some other things. The bill passed the Senate last year, and due to the abbreviated session, didn't make it back over here for you to deal with. And the Speaker Pro Tem was the sponsor last year on the House side, and we're trying to move it forward to help these individuals and make access to fresh produce to our citizens at these farmers markets and on the roadside stands. I think we have several or a few witnesses signed up that will clarify more how it pertains to them particularly, and I ask for your favorable support for House Bill 841.
Thank you, Delegate Otto. Colby Ferguson.
Thank you, Mr. Chair, members of the committee. Colby Ferguson on behalf of Maryland Farm Bureau, and we come in support of House Bill 841. I think the biggest things that I want to make sure, obviously we've had the Senate bill hearing and hearing of the opposition to this bill, probably some misinformation or misunderstanding, and if it needs to be narrowed, then the focus of what this bill is assuming to be done, then that's fine. I know that when we had the minimum wage bill back several years ago, I know one of your members of this committee, Delegate Mounts, was very instrumental in getting our ag exemption in, and this was a component that ended up not making the cut. But really, the focus here is on those individuals that are in that age group of about 16 to 21. They're typically high school students or college age students that don't have the ability to take on a full-time job. They're looking for those specialty type jobs that are maybe 2 to 7 weeks in time, and maybe only have 1 to 2 days that they work. And it looks good on their resume for college. It also looks good on National Honor Society resumes. And so we're not actually looking to take the single mother with 5 kids and not allow them to have the full minimum wage. We're looking at these very specialty type operations, and if the need is to narrow the focus to the 16 to 21 years of age, we're fine with that as well. But I can take more questions as my time is running out. But definitely the focus here is on these farmers markets, these pumpkin patches, corn mazes, the Christmas tree farms that are really only open for 6 to 7 weeks at a time, maybe only 2 weeks, and really is not a full-time position at all. So with that, we'd ask for a favorable report.
Thank you. Matthew Tifo.
Thank you, Mr. Chairman, Madam Vice Chair, and members of the committee. For the record, my name is Matt Defoe, and I'm here today as a Caroline County Farm Bureau member in support of House Bill 841. This bill is very important to our farming community, especially your smaller family-owned farms that give youth the opportunity to have a summer job, make some money for either college, a car, or savings. I was fortunate enough to have such a great opportunity growing up in Caroline County. For 6 summers, I worked on my friend's family farm, picking peaches, apples, and other fresh local produce. Got a little photo remembrance here of me picking peaches, something I keep in my office just to remind me, where I came from and kind of humble beginnings. But what made my experience different, but not uncommon, is that and this is why I'm supporting the bill, that my main job was to pick fresh fruits and produce, but I was also able to work on the weekends in the retail part of the farm or sell produce at local farmers market. So working on the farm taught me a lot of life lessons, hard work ethic, showing up on time, how to drive a tractor, and understanding where our food comes from. Other benefits small farms may offer are at the end of season bonuses, which for 2 years paid my college books. But most importantly, if you work hard, that you're asked back the next season to receive a pay increase as well. So with that, Colby said a lot of things about how this being a first job, and it's not your typical 9-to-5 retail job. I just want to thank the sponsor for putting this piece of legislation and ask for the committee for a favorable report. Thank you.
Thank you. Ricardo Winchester. Is Ricardo Winchester with us? If not, Sally Dork Fisher.
Good afternoon. Can you hear me?
Yes.
Okay. Thank you, Mr. Chairman, members of the committee. My name is Sally Dworak Fisher, and I'm an attorney at the Public Justice Center, which is a nonprofit legal organization whose mission is pursuing systemic change to build a just society. Our workplace justice project protects and promotes humane working conditions through litigation and public policy, and we are in strong opposition to HB 841 for 4 reasons, and I realize my time is limited, so I will direct you to my written testimony that I've submitted. But the 4 reasons basically are: number 1, and fundamentally, this bill would undermine the basic purposes of our wage and hour law, which further weakens its bedrock protections. Number 2, there's vague language in the bill that creates a potentially dangerous loophole. Number 3, it's not necessary in light of existing exemptions, and it's particularly troubling in the midst of a pandemic. And number 4, this bill is likely to hit disproportionately workers of color. As the General Assembly recognized when you passed the Maryland Wage and Hour Law years ago, the basic law has 4 purposes. It is to provide a maintenance level sufficient for the general well-being and health of all Marylanders. It is to safeguard against unfair competition. It is to increase employees' buying power, and it's to decrease the need for workers to turn to public assistance as a result of low wages. This bill would carve out additional exemptions for certain businesses, depriving their employees of the bare minimum wages set in Maryland and undermining the purposes of this act. Particularly now, as Marylanders are struggling to put food on the table and pay the rent, eliminating their right to be paid what has been deemed to be the bare minimum would be a step in the wrong direction. Our written testimony further details our objections to this bill. And in my limited time remaining, I just want to point out that I believe the fiscal note mentioned that these employers would still be bound by the Fair Labor Standards Act. I will say that that's not necessarily true. That federal legislation covers only entities with annual sales volume of more than $500,000 per year. So to the extent that we're talking about the small mom and pop agricultural stands here, those folks would now be not covered by any minimum wage and overtime law. So in short, we oppose HB 841 and we urge an unfavorable report. Thank you.
Brig.
Good afternoon, members of the committee. My name is Bridge Dumais. I'm the Fight for 15. We oppose this bill, which will gut the $15 an hour minimum wage. This committee and the majority of the legislature agreed that $15 is needed because there's nowhere in the state where anyone can get by with less. Furthermore, this committee agreed last session that the previous bill should not pass, the previous version of this bill. Compromises were made in 2019 that exempted too many workers, including youth and agricultural workers. However, we did agree that 15 should apply to retail workers. The definition of retail is the sale of goods to the public in relatively small quantities for use or consumption. So workers at farm stands are and should continue to be classified as retail. Raising the minimum wage spurs much needed economic growth, which benefits businesses. With COVID-19, this is more urgent than ever. Workers are customers too. Raising wages empowers the lowest paid workers to participate in the economy, thereby increasing demand for goods and services. Small businesses are at a competitive disadvantage when wages are low because their prices tend to be slightly higher and workers will shop where they can afford. Higher wages save businesses money. Frequent turnover in low-wage jobs means businesses have to spend more on recruitment and training than they would be spending on retaining their workers by paying them higher wages. Better wages lead to better customer service, fewer mistakes, and increased productivity. Good customer service generates repeat customers, which brings steady revenues for businesses. Reducing errors and increasing productivity also saves money. Our minimum wage is not yet $15, so efforts to erode the wage floor are disappointing. Adding insult to injury, workers that would be exempted if this bill passes are essential. Now is the time to pay them more, not fight to depress their wages. The economy is only as strong as the lowest paid worker, and HB 814 will leave more working families behind. When workers do well, the economy does well. So please vote no on this bill. And I would like to highlight again that many of the workers that would be exempted through this bill are already exempted under current minimum wage law, including youth and immediate family members of business owners. Thank you.
Terry Kavanaugh.
Good afternoon, Mr. Chairman, members of the committee. Terry Kavanaugh with the SEIU, Maryland, DC State Council. We're in opposition to the bill. I'll try not to repeat what others have already said. What this appears to be is an erosion of the bill by the same forces that were against the Fight for 15 law. They were against the 1010 law and probably against the minimum wage law altogether. On the specifics, this is not very well defined. What is an agricultural stand? What is a retail farm? What is a farmer's market? Is the Baltimore Farmers Market, where thousands of people go every week from April through December, is that a farmer's market? And would those folks be under no longer protected? It's been characterized as this is little Johnny selling apples at the end of the lane or picking peaches. But in some places, these are larger employers in their micro labor market, whether it's in western Wacomico County or Dorchester County. And if you allow them to undermine the labor market, who else should be exempt? There was one example in the Senate hearing about Wright's Market, and they're as described on their website, a large-scale retail farm market that includes selling Amish-made furniture, home and garden items, giftware, an in-store bakery, and on-site greenhouse. That is not someone who should be exempt from the Fight for 15 law, and we ask an unfavorable report. Thank you.
Thank you. Chuck Cook.
Thank you, Mr. Chairman, members of the committee. Chuck Cook with Maryland State and DC AFL-CIO. So as everyone on this committee knows, this is an incredibly compromised bill from the beginning. We worked on it for several years, worked across the aisle with opponents to try to find reasonable exemptions. So we have 14 exemptions in our Maryland wage and hour law, 4 of which directly relate to agriculture. I think Bridge made a really good point before that I want to follow up on. This is retail. Right, we're moving into the realm of retail. I'm sure that Giant and Safeway and Shoppers and every other place that sells produce would love to be exempt as well. So we don't know where it ends at this point. We don't need to exempt retail workers. It's just not necessary. And to the point of, well, maybe we can talk about something in the 16 to 21-year-old age group. Well, great news. We already have an exemption between 16 and 18. There's a lower minimum wage anyway. That was already put into the law. So these already exist. And just to back up the other folks on here who are opponents, it's just picking away at existing minimum wage law. And we think that it's completely unnecessary at this time. So we would ask for an unfavorable as well.
Thank you. Corey Johnson.
Good afternoon again, Mr. Chair, Madam Vice Chair, members of the House Economic Matters Committee. For the record, again, my name is Corey Johnson, and I'm an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force, where our mission is to eliminate barriers to employment for low-skilled, low-wage workers. We strongly oppose House Bill 841 as it ensures the poverty of a large amount of Maryland workers. In 2019, we fought hard to change the minimum wage standards for the state of Maryland to reach $15 by 2026. Currently, however, the minimum wage in the state of Maryland is $11.75 an hour. HB 841 would completely eliminate that standard for even more members of the agricultural workforce. I urge the committee to recognize that all individuals should have access to a livable wage, especially now during the pandemic as our communities are at their most financially vulnerable states. All Maryland workers should be exempt from slave labor, no matter the industry or the season. The People's Law Organization identified that the living wage in Montgomery County, Prince George's County, Anne Arundel County, Baltimore City, and Baltimore County is $14.42 an hour for a family of one. Further, with the average household size in Maryland being 3 individuals, the MIT Living Wage Indicator notes that a poverty wage for a family of 3 with 1 working adult and 2 children is $12.64 an hour. This means that even our current minimum wage does not even ensure that individuals can live at the poverty line. HB 841 would not only eliminate agricultural workers from the opportunity of making a livable wage, but it would essentially be a poverty sentence for many Marylanders. Agricultural workers make up Maryland's lowest paid workers at an average salary of about $35,000, despite agricultural workers being the largest commercial industry in the state of Maryland, employing about 350,000 people. That's 350,000 Maryland residents that would suffer. Finally, HB 841 would increase the racial wealth gap that is already looming over Maryland's economy. The unemployment rate in Maryland is 3.3%, yet the Black unemployment rate is 6.1%, and the U.S. Bureau of Labor Statistics already reported that 32% of agricultural workers are Black and Latino workers. For these reasons, we urge an unfavorable report.
Delegate Mounts.
Thank you, Chairman. I'll be very quick. I just this hearing just hits really close to home for me. I spent a number of days with a gentleman named Stephen Blades at Caroline County Blades Orchard, where they have a stand, a roadside stand. I spent with him and his daughter. His daughter used to run the crew. And they had a crew of kids who worked there, and they had seasonal work, and it was a group, and they benefited widely. And they lost that crew. That no longer exists. And they're very disturbed about this. And I heard Wright's Market mentioned, and I frequent there whenever I pass by, and I talk to the employees there. And I think most people that stop in see a roadside retail establishment, but if they took time to talk to the people who were there, you'd find out that they weren't just working in that stand. They spend just as much time in the fields picking as they do in a store selling. And some of the testimonies kind of gotten to a point. I just wanted to pose this question to Colby Ferguson, because I know Colby is understands this very well. It's hard to articulate, but Colby, why is a flat wage, whatever it's set, why is that problematic for these businesses and the way they operate? I think they're different and they're unique. And if this exemption is created, who really benefits from the exemption? Who's going to reap the benefit? Because I know Blades Orchard is going to stay open, even though the kids don't have a job. Blades Orchard actually had the best year they've had in a long time without the youth employment. And so why is this wage issue such a big deal for these stands? And then who really benefits?
Thank you, Delegate Mouts. You kind of hit the nail on the head when you kind of went through your summary of some of the jobs that are out there. And honestly, this comes down, and that's why I've kind of focused my limited time talking about the 16 to 21 year age. Most of the cases, because these jobs that we're specifically targeting in this bill, not all the workers that were brought up under some of the opponents that we're talking about, but these very specialized and honestly, they're first time jobs. In many cases, a lot of these farmers nurture these kids. They come in, it's their first time to ever have a position, have a job at all. They can only work on the weekends, maybe a Saturday or Sunday because of football practice or for whatever, because of school's in during October, during the corn maze or the pumpkin patch type things, or even the Christmas tree farms. I guess my biggest thing is these farmers are going to do more with less. They're asked to do more with less every time. And if the minimum wage continues to go up, they're just going to do more with less. So if I can give you an example of a farmer in Frederick County. She hires for the pumpkin patch corn maze program, which is the month of October. She hires about 100 kids. And when I say kids, I'm talking 16 to 18 years of age, because she's only open doing this basically Saturdays and Sundays. And a lot of these kids, half of them work on a Saturday, half of them work on a Sunday, and they're open for about five weeks, roughly the end of September through the end of October. And these kids get an opportunity to work. And if we increase the price of the cost by 33%, you're going to lose 33% of those jobs, because the cost cannot be, that the pumpkins are still $2 to $5 a piece. The cost is still where it is, and you can't just incur that cost in a low margin environment that you have. So in short, it's 99% of these jobs we're talking about are these 16 to 18, 21-year-old kids that is in a lot of cases their first job, or in a lot of cases is they're just trying to do something to make some extra spending cash, like Mr. Defoe talked about earlier.
Thank you, Colby.
Thank you. Delegate Pippi.
Thank you, Madam Vice Chair. Yeah, I just had a quick comment. The bill says for certain age groups, right? I don't know, maybe this is a question for Mr. Ferguson. I heard the term slave labor, and then I was reading the bill and seeing under the age of 17. So can someone square that with me? I mean, are these people with kids trying to raise families at these fruit stands? Or Colby, can you help me out with that?
Get back off mute. So basically, the way the exemptions are in the current rule, in the current law, is it's under 16 if it's just I think it's number 3 of the 14 exemptions. Number 3 is under the age of 16 and is employed for no more than 20 hours in a week. So there's where the problem is, because when you roll down into what they talked about, the ag exemption, that gets into hand labor, hand harvest labor, and doesn't really get into the farm stand side of it, or the pick your own pumpkin patches and things like that. And so really what this bill is specifically targeting is those individuals that got missed. We asked for that number to be higher than 16, and it just didn't happen in the original law. So this bill is just coming back, just asking to cover those young people in there, so we don't lose those jobs. So I don't get the discussion of I mean, I'm not even going to say what was said, but I don't get that, because I don't think that's the workers that are being targeted in this bill. I think those individuals are paid extremely well, and are very valuable. These positions we're talking about here are very small, it's 2 to 7 week positions that are maybe 1 to 2 days a week.
Yeah, I mean, I would just say, I worked at a Christmas tree stand when I was in high school for many years. I wasn't raising a family on it. I mean, I was under the age of 17 in high school, and it was just about, growing, learning a skill, learning how to talk to people. I was living in my parents' house. So I'm not sure if we're squaring this bill versus some other activity that some of the opponents were bringing up. But thank you for answering that.
Madam Vice Chair.
Yes, Delegate Adams.
My raised hand, I can't figure out how to work that today. Colby, I have a question for you. You know, when I was a kid, I worked 2 summers at a farm, and then that translated and also the farmers market out on Route 50. So not Wright's Market, but very close to that. And what would happen is my dad would drop me off like 5 a.m. at the farm. We'd start picking corn. By the time the leaves of the corn, dried, you couldn't work in the cornfield. So then you worked pulling cantaloupes or watermelon, any number of things that the farmer needed done. And so what we'd do is we'd have lunch at the farmer's market, and then we'd start working the farmer's market, stocking the shelves and working with customers, And so what I'm hearing you say is that, the same thing I was doing when I was a kid for 2 years is still in practice today, and that, the mornings when they're working in the fields before it gets hot, the current exemptions allow for that. And then the afternoon part of that job, which me as a 15 or 16-year-old, however old I was when I was doing the work, I want to continue working. I want to be there during the summer season, and that this bill, the way that it's drafted, helps somebody like me when I was 16 years old actually carry that kind of job and make more money at the time where, okay, now it's hot, it's summertime, I can work under the shade of a retail stand. I'm thinking about Wright's Market, and boy, I only wish that we had it that good back when I was a kid. But the idea is that that's a multifaceted job that they're bringing young people in. It's not a unionized job. I'm not sure where the prerogative here is that we're trying to present this global cataclysm that's going to come because we're asking for this change. It's rather to help young people. I don't mind saying I learned a lot. Work ethic, showing up at job early in the morning and being willing to work with my hands. I would imagine that you would see this as an essential bill that helps expand that, certainly in the rural parts of our state. Would you agree?
Isn't that so?
Yes, I would agree. I would say that yes, that's what we hear from a lot of our farmers is that they nurture these kids. Most of these are family. 99% of these markets are, well, probably 100% are all family operations. And so, a lot of the times the kids that are working in the market are friends of the kids of the family. And, they want to bring them in. They're like, hey, you want to come and work with me? And they're like, yeah, you're going to pay me to come and play on the farm. And so, that's where we're having the problem is that you get into that. And these are young people that are being nurtured by the family that runs the farm. And so you get into that discussion of, it's difficult for them to pay that kind of money. And what it happens is it just reduces the number of kids that'll have the opportunity.
Thank you very much, Mr. Ferguson. We appreciate you coming in today. We appreciate all of you that have testified on this bill. That concludes the testimony on this bill, and we will now move on to our last bill of the day, which is House Bill 1326. Happens to be my bill. The chairman unfortunately had to leave for a meeting, so I'm going to make a brief presentation and then we will move through the witness list. This bill, I know, based on looking at the witness list, that there's a long list of businesses, et cetera, and probably some committee members that are sort of very concerned about what the bill purports to do, which is basically to expand healthy leave or the Paid Sick Leave Act to include some of the disasters that we've seen with COVID. What I want to caution everyone is that similar to House Bill 581, which was the chairman's bill, I think we've all been inundated with the number of different advocates on both sides of the issue, from the employer side and the employee side, that are struggling with what this pandemic has caused. This is simply one suggestion or one proposal for what we can do. We're going to have to work on 581, which everyone's aware. Clearly, we're going to have to work on this one. But I do think that it's important that we at least hear the testimony from both sides, and that we put our, keep our work groups together or the current work group together, and we try to address the struggles employees have had, and certainly the struggles that businesses and employers are having. Please don't think that I'm not sensitive to the fact that employers are struggling. I'm an employer and I get it. But at the same time, the testimony that you're going to hear about some of the struggles that employees have had to go through are certainly worth our attention to try and find the right solution. If 1326 is written isn't the right solution, then let's find what it is. And that's the philosophy or the premise that I would like all of us to keep in mind as we listen to the testimony today from the two very different perspectives, one the employees and one the employers. Now, so with that, I'm actually going to ask Ms. Robinson, Tyra Robinson, to testify first. She's going to sort of walk us through the bill and give you the perspective of the reason the Public Justice Center is so interested in having this done. And again, it is one of a myriad of bills that we are hearing over the course of this session, trying to deal with the struggles on both sides. Ms. Robinson.
Yes, thank you, Delegate Dumais, and thank you for your sponsorship of this legislation. Good afternoon, members of the committee. Again, for the record, my name is Tyra Robinson. I'm an attorney with the Public Justice Center. PJC was a founding member of the Working Matters Coalition, which helped pass the Healthy Working Families Act, which establishes for workers the right to earn 1 hour of sick leave for every 30 hours that they work. I'm here this afternoon to urge your support on HB 1326. So the basics of this bill are to expand Maryland's sick leave law generally to cover agricultural workers, temporary workers, and on-call health professionals, because these groups that are excluded from the law get sick too. Also, the bill will alter the family definition to bring it up to date with national shifts and more inclusive and modern family structures. And finally, the bill will establish additional amounts of time adequate to respond to a public health emergency. You're going to hear a lot of opposition with respect to a couple of issues today, and I want to address those at the outset. First is employer costs, and second is that these changes are unnecessary to the law. We acknowledge that there are concerns about employer burden and costs, and these concerns are reasonable, but we also recognize that we have to do something about the impacts to workers. Workers in a typical non-COVID year usually need to take off work due to illness at least once. During a public health emergency under which this additional time will be available, every worker may not necessarily need that entire period. And in that circumstance, an employer would only be required to pay the employee for the days that they do need off. And let me be clear, this is not an us versus them situation. We're not trying to put folks out of business or shut down businesses. We're happy to engage in solutions so businesses can afford this and workers can be protected. Second, these amendments are reasonable and we believe they're necessary. We know that employers are doing their best to be flexible with workers during the pandemic, and we also know that some employers are putting their employees, patrons, and communities at further risk of danger when they make their employees come in sick or will not allow them to use their current earned sick and safe leave to go get tested. There are gaps in coverage of who have access to sick leave, and these gaps are occupationally based as the current sick leave law is. Any further gaps will further expose Maryland to outbreaks and weaken the health of the state overall. Finally, I'll close with this. This bill fills a critical gap in public health and workplace protections by recognizing that everyone gets sick and deserves time to recover without jeopardizing their economic stability and community health. 3 days shy of the state of emergency declaration by Governor Hogan for coronavirus almost 1 year ago, we urge a favorable report on this legislation. Thank you.
Thank you, Ms. Robinson. Is Flora Gary here?
Yes, I am here. Just
okay. Would you like to go next?
I can go next. You just give me 1 second, please.
All right. We're having a hard time hearing you.
Okay. Yes, I'm here and I'm ready now.
Okay.
Thank you. Good afternoon. My name is Flora De Maria Garay. I'm here today to testify on behalf of my mother who lives and works in Frederick, Maryland, District 3A. She provides home care support for a development disability employer, and she really enjoys her job helping clients with intellectual and developmental disabilities, which is something that I admire about my mom. We had a scary situation in January. My mother tested positive for COVID-19 exactly on the first week of January after the federal law that provided for paid sick leave to workers who contracted or were exposed to COVID-19 expired. While sick from COVID-19 and experiencing all the related symptoms, she called me to ask for help because she didn't know if she qualified for any of the available paid sick leave laws. So we immediately informed her employer about the positive result and asked her for leave under the Maryland Healthy Working Families Act or Families First Coronavirus Response Act. Her employer responded that she only had 12 hours of sick leave available through the Healthy Working Families Act. So that meant that she had less than 2 work days to quarantine and recover from COVID-19 before she lost any job protections. Worse, my grandmother tested positive for COVID shortly before my mother did. Because my grandmother was staying with my mother at the time, she was the only care provider for my grandmother. My grandmother is 86 years old and at high risk for a severe illness for COVID-19. Despite my mother being sick with COVID herself and my grandmother almost at the brink of death, my mother was able to provide her with the sufficient care to allow her to recover. As a result of having to take care of my grandmother, my mother's symptoms prolonged. It was not until early February that my mother recovered and was able to return to work. This was a scary experience for our family. My mother is blessed and lucky to have made it through, but it was difficult to do so without a paycheck and any other job protections. What happened to my mother is just one example of the many workers who currently do not have enough leave to stay home to care for themselves or their loved ones. I know that Maryland can do better to protect our families, our working families, and this is why I'm urging for a favorable report on HB 1326, because although the current Healthy Working Family has helped some, it is not enough time for any worker or family relative to completely recover from COVID, and absolutely won't be enough time if that same worker gets sick again from anything else this year. Thank you for your consideration.
Thank you very much. Corey Johnson.
Good afternoon again for the final time, Madam Vice Chair Dumais and members of the committee. Once again, for the record, my name is Corey Johnson and I'm an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force, where our mission is to eliminate barriers to employment for low-skilled, low-wage workers. One of these barriers being access to sufficient sick and safe leave. We strongly support HB 1326, extending the parameters of the Maryland Healthy Working Families Act to sufficiently cover working individuals during a public health emergency, similar to the pandemic we are experiencing now. I would first like to thank Madam Vice Chair for the timely introduction of this bill as we now struggle with the repercussions of the unprecedented public health emergency. The Maryland Department of Health reported that there have been 382,702 confirmed cases of the virus in the state of Maryland, and 7,697 Marylanders have died. The effects of the pandemic have been unforgiving for marginalized individuals across the country. As Lisa Cook, a Michigan State professor, indicated, as a result of the pandemic, every corner of inequality has been exposed. This statement holds particularly true in the state of Maryland. Although Black residents make up 30% of Maryland's population, they make up 41% of COVID-related deaths. Further impacting the marginalized workforce, nearly 4 times as many women as men dropped out of the labor force in September 2020, roughly 865,000 women compared to 216,000 men due to pandemic-related causes. Consequently, the COVID-19 pandemic has illuminated the shortcomings of the sick and safe leave provision of Maryland law. No one should have to choose between their health and their job, yet an absence or delay of earned sick leave makes this choice ever present for working families. Moreover, I would like to echo Tyra Robinson's statement that this legislation would protect small businesses as well by allowing sick employees sufficient sick leave that promotes safety in the workplace and shields employers from liability of facilitating unsafe work environments and exposing consumers to unhealthy conditions. For these reasons, we respectfully urge a favorable report.
Thank you very much. We have just a few more proponents and then I'll move to questions. Carla Gilbride.
Thank you, Vice Chair Dumais, for your time and for introducing this important legislation. My name is Carla Gilbride, and I'm speaking here today on behalf of the Marylanders for Food and Farm Worker Protection, which is a coalition that formed in response to the COVID-19 pandemic to advocate for the interests of agricultural workers throughout the state of Maryland, for farm workers, for seafood packing workers, and for workers in meat packing plants. The list of members of our coalition and endorsers of HB 1326 appears in our written testimony. I'm speaking today in favor of this bill for 3 reasons. Specifically, removing the exemption from paid sick leave for agricultural workers and expanding the amount of paid sick leave in public health emergencies like the current pandemic is particularly important for the agricultural workers who are the backbone of our food system. It's important that agricultural workers be included as a matter of a moral imperative and human dignity because they are essential workers. They get sick just like everyone else. And if they are not able to remain healthy, it places their families in jeopardy. It places our food system in jeopardy, and they should be treated as a matter of equal dignity with all other workers. Secondly, including agricultural workers in paid sick leave is a matter of racial equity. Black and brown workers are disproportionately represented among the ranks of farm workers and meatpacking workers, and they have died at disproportionate rates from COVID-19 since the pandemic began last year. Thirdly, including all workers in our food system and providing them with paid sick leave so that they don't have to choose between a paycheck and their health is important to protecting the public health. Some of the largest outbreaks of COVID-19 have occurred in the food sector because workers in meatpacking plants work in crowded conditions, often in close proximity to one another, are often transported to fields in crowded transportation vehicles where the spread of contagious diseases is where there's a high risk of one sick worker infecting others. And those infections and outbreaks are not confined to the workplace. Once an outbreak has taken hold in a meatpacking plant or other place where people are working in close confined conditions, those outbreaks spread into the surrounding community. And so providing this essential public health protection will ensure the safety not just of the workers themselves, but of their families and of all Marylanders. So for these reasons, we strongly support a favorable report of HB 1324.
All right, thank you, Ms. Gilbert. Ricara Jones.
Good afternoon, members of the committee. My name is Ricara Jones. I am the political director with 1199 SEIU. We represent healthcare workers in hospitals and nursing homes across the state. I think we've all known for quite some time that workers need paid time off to care for themselves and their loved ones when they're sick. But the recent pandemic has really highlighted an even greater need for this legislation. So I just want to thank Vice Chair Dumais for sponsoring this revision bill because it provides some much needed changes to the existing law. Throughout the pandemic, frontline essential workers, they didn't have the luxury to work from home, and many of them have risked their lives and lives of their families to show up to work in person. And they've had to utilize this leave more than ever. But unfortunately, as you've heard, some frontline workers are not covered by the existing legislation, such as agricultural workers, temp workers, and on-call health professionals. And some of these workers felt forced to go to work while they were possibly infected, therefore exposing their coworkers and other people and directly contributing to the rising numbers of COVID-19. We know COVID-19 hit communities of color really hard. And one of the reasons is because according to the Economic Policy Institute, over half of essential workers in the state are workers of color. So we just cannot continue to sacrifice our most vulnerable workers by denying them much needed protections. So there's a lot of reasons that we support this bill, but just the last one is because the bill isn't about workers versus businesses. These changes are necessary because there is no way businesses can survive without healthy employees. I think we're going to hear that employers are going to say they can't afford the changes, but we can't afford to lose another frontline worker. It took us 6 years to pass this legislation, and we are currently in the midst of a global pandemic, so we have no time to waste. I'm really asking this committee to quickly and swiftly give a favorable report on this bill. Thank you.
Thank you very much. Teresa Hessler.
Good afternoon, Madam Vice Chair, Chair, and members of the committee. My name is Teresa Hessler, and I'm here representing the March of Dimes in support of House Bill 1326. For over 80 years, March of Dimes has helped millions of babies survive and thrive, And now we're building on that legacy to level the playing field for all moms and babies, no matter their age, socioeconomic background, or demographics, and to work to advocate for policies that prioritize their health. The COVID-19 pandemic has created an impossible situation for working parents, forcing them to juggle their job responsibilities alongside childcare and homeschooling while keeping their families safe. This legislation would expand the Maryland Healthy Working Families Act, allowing for flexibility during a public health crisis such as COVID-19. If passed, House Bill 1326 would offer additional sick and safe leave under certain circumstances, ensuring financial stability to those who need to care for a sick family member or new baby, as well as a child whose school or daycare has closed due to a public health crisis. If this pandemic has taught us anything, it's how fragile our country's support system is for our youngest and most vulnerable citizens. Families in every state should be free from making the agonizing decision of financial security or the health of her family. It is imperative that we bolster support for struggling families, including improving emergency paid sick days and leave policies. To close these gaps and protect the health of families during the pandemic and any other public health crisis, March of Dimes urges a favorable report on House Bill 1326. Thank you.
Thank you. And the final testimony on the proponent side, Tom Cole.
Yes, thank you. Tom Cole on behalf of Strong Future Maryland. We strongly support House Bill 1326 and request a favorable report from the committee. We've submitted written testimony, which I'm not going to repeat here, and I'm going to try my best not to repeat the great testimony of proponents that's already been offered. What we wanted to comment on is the cost, because we're going to hear a lot in opposition in terms of what the cost is. What we realized over the past year is that the holes in our public health system have significant and lasting costs. How many times has an employee been forced to make the perverse decision between whether or not to follow public health guidelines and stay home or go to work, whether or not they give up their paycheck for their health? These are decisions that we don't think employees in Maryland should have to make. So we think, first of all, that the holes in the current Paid Sick Leave Act should be filled, that we should cover these additional workers. But then second of all, when we have a public health emergency, it is all the more imperative that we allow these employees to stay home. What is the cost for a business that doesn't offer sick leave to a sick employee and it spreads the illness to another employee? What is the cost of losing employees who had to make that choice and caught the disease and did not recover? How many times have businesses had to close because they've had an employee show up to work that's been discovered to have COVID? And then also, what about those employees that are known to have health conditions that are forced to go to work because they don't have paid sick leave? COVID-19 has exposed for all of us the inequities that are in our public health system. And this legislation serves a critical purpose in filling in those inequities and making sure that we can face a public health crisis with equity and inclusion. And so we strongly urge a favorable report on this bill. Thank you.
Thank you. We will have questions for proponents. Delegate Charkoudian.
Thank you, Madam Chair. Thanks for bringing this bill. I do appreciate, I do have questions, but I did want to say, I appreciate your opening comments. And I agree that we have a lot of bills that are kind of coming out of the pandemic, but I think that's absolutely appropriate. I mean, we've just all experienced as a society some of the most traumatic things that we'll ever experience as a society. And so I do think we need to be very thoughtful about all of the changes that are necessary to respond to both where we are in this moment, but also where we could be again. I think we've seen things that were unimaginable to us before this year. And so thank you for bringing this. And in trying to understand it, I think that I do understand, well, I guess I have a couple questions that maybe is for Tyra, although others could jump in on it if they have the answers. So starting with the section that seems to be new related to, now I'm like pointing to it like you can see my computer here, related to the public health emergency. I'm just wondering, I'm scanning it quickly now, but if you could, I mean, I've heard some folks say, especially on the earlier bill, you know, we're basically almost through COVID. We've got the vaccines. I'm afraid COVID is probably with us for a while longer, but and so we do need to make decisions based on that. But if I understand this, maybe this could be presumably another kind of a public health emergency beyond COVID. Is that So that's my guess. My first
That is what the
question.
language currently says, but again, the work group for House Bill 581 has really only met once so far, and I don't have the language actually in front of me, but this is a section that we actually did discuss in that work group and narrowed so that it is very clear that we are talking about some sort of a pandemic and we tie it to the calling of a state of emergency.
But it would be a pandemic
That's
potentially.
exactly what we'll do here, but I do think, narrowing it so it is addressing what we have seen is one way of looking at this. And I don't know if Ms. Robinson wanted to respond.
Sure, I'll just briefly add, I'm sorry, Delegate Treckley, and just to directly answer your question that you raised already, it's on page 4, I believe, and the definition is a declaration or proclamation related to a public health threat, risk, disaster, or emergency that is issued by a federal, state, or local official with the authority to make such declaration. And so it is directly tied to a declaration that is made by an official. And so in that way, it can directly respond to COVID, but also if this happens in the future, any future public health emergency or emergency as defined in the bill text, a public health emergency, that is specifically what this bill addresses.
Okay, right. So, and I guess in my mind, it makes sense because we could theoretically, God forbid, have a massive pandemic again in 10 years, right? And this would sort of be the way that we're ready for it in advance. Okay, so then once that emergency is declared, right? Like once there's enough of a situation that looks roughly like COVID did, can you just help me understand exactly what happens? Then it adds to the amount of paid sick leave that is available to the employer, is that right?
The employee, right.
Is that correct? So that theoretically that would allow for the quarantining. I mean, I guess we're hearing about folks whose sick leave ran out, had to quarantine, or got sick, had to quarantine, sick leave ran out. Like that's what we're working on. And that's what those sort of additional hours are allowing for. Is that sort of the math on that is what it might take to quarantine? Okay. And then I think the last question I have, so that all, I appreciate that. And then I think the last question that I have is, there's a number of, at the beginning of the bill, there's the folks who had been exempt from paid sick leave when the bill originally passed. And it looks like this sort of includes now everybody. It pulls out those exemptions. And I was just wondering what the reasoning had been, if anyone was involved in some of those initial policy conversations that led to these exemptions. I think this was before I was in the General Assembly.
It was actually before I was as well, although I've heard some of them. But Ms. Robinson, I think you probably were involved in it at that point.
I actually was not, so I apologize that I cannot directly, say what happened before I arrived. But I know that a lot of the exemptions were a result of compromises. And even the public health emergency portion, that too was a compromise to get this bill passed back when it was passed before I arrived. So I apologize, I can't directly answer to what happened before I was here, but those exemptions are a result of compromises that occurred before my time.
Yeah, and that is my understanding as well.
There wasn't, I just was wondering if there was an explicit policy reason for temporary employees, for example, or temp services.
I have a feeling we will hear about it from, there's a long list of opponents, and I think that they will remind us of what the discussions were.
I will ask them questions. Thank you all very much.
Okay, thank you. Seeing no further questions, we're going to move to the opposition testimony. I have Mark Bain first.
Thank you, Economic Matters Committee, for allowing me to testify today. I am in opposition to H Bill 1326. My name is Dr. Mark Bain. I'm the co-owner of Comprehensive Nursing Services. We are a licensed RSA in the state of Maryland for over 33 years, and I'm also accredited by the Joint Commission. There's two main points I'd like to make today. One is my fear is the expense of this would cripple our industry. Most RSAs that provide home care our payer is Medicaid. And as you well know, our Medicaid our rates are capped. We could not increase our rates in order to compensate for paying nurses more money. In fact, 2 years ago, the governor committee deemed that our state was paying a rate about 24% less than our surrounding states. And I can tell you, and I can speak freely, that anybody in this industry, when we do get a fee increase, we immediately pass that on to our nurses. We have, we're paying, the FICA, workman's comp, federal and state unemployment, medical malpractice, healthcare, and due to this COVID crisis, we are now providing, personal protective equipment, hand sanitizer, disinfectants, and gloves. Many of our clients have actually opted out to using home care nursing due to the pandemic, and we've also lost a lot of revenue due to schools being closed for in-person learning. My second point I'd like to bring out is the degree of fraud. Many of these nurses are temporary employees, and they are signed up with several different agencies. And today we have these nurses that'll call out on a case of mine because somebody offered them $2 more an hour, and then what they would be doing is the same thing, working another case and collecting sick time from me. And who is really going to suffer here? It is the patient and their families. Thank you for letting me testify today.
Thank you very much for being here today. Ashley Duckman.
Thank you, Madam Vice Chair, members of the committee. For the record, Ashley Duckman here on behalf of the Maryland Chamber of Commerce and our more than 5,000 business and federated partners from across the state. I have appeared before this committee many times. I feel like I'm a broken record at this point, but I do think it bears repeating because we've heard so many times today about the unprecedented health impact of COVID-19, which indeed is predominant, but I also don't need to remind this committee about the parallel unprecedented economic impact of the pandemic, economic implications that are real, vast, and probably fully unrealized at this point. We don't have a crystal ball. We can't predict when the state of emergency will end, when we'll fully resume commerce, when we'll reach our full economic recovery. And, again, simply put, the bill before you today, which requires employers to provide an additional 3 full weeks of paid leave, has massive cost implications that Maryland's job creators simply cannot afford right now, particularly as they grapple with other state mandates like our original paid sick and safe leave law and minimum wage increase, not to mention other policies and initiatives presently being considered by the General Assembly that might be forthcoming. Just to put it into perspective quickly, as an example of the very real impact this bill will have on employers, I was contacted just yesterday by a large Maryland employer who ran the numbers and firmly believes with conviction that the bill will force them to transition most of their hundreds of Maryland positions to other states simply because of the cost impact. Another great concern of ours is the fact that all employers will be required to provide the additional paid leave, and that small businesses with 14 or fewer employees who are presently not required to provide paid sick and safe leave will be required to do so under this bill. And I know I don't have to tell this committee how badly our small business community is struggling right now, and I'm certain that my colleague from NFIB is going to add some additional context there. So while we believe that House Bill 1326 is well-intentioned, and we certainly do acknowledge the challenges and questions raised by many of the proponents of the bill, simply put, it has to be considered in balance. We have to, balance the fact that our employers are struggling to comply and pay for previous mandates. And so we look forward to working with the committee on this and other issues to try to find that balance. But for these reasons and the ones based in our comprehensive list of concerns outlined in our written testimony, we respectfully request an unfavorable report on 1326.
Thank you, Ms. Duckman.
Thank you.
Mr. McCullough. Is Mr. McCullough here today?
Yes, I am. Thank you very much, Madam Vice Chairman.
Sure.
Jan McCullough on behalf of the Maryland AGC, which is a trade association for commercial construction companies. I'm not going to belabor the cost issue because I think you will hear more than enough about that. But let me point out some concerns that we have about the bill, even if at some point and in some configuration it were to pass or be incorporated in other legislation. 112 hours is an extraordinarily generous provision. That's almost double what the normal Maryland Healthy Working Families Act would provide for leave. And it is really unreasonable to pick such a long period of time. If anything, we should not make any assumptions about what a future medical emergency might look like. And so use science rather than legislation to determine what additional leave, if any, or what other prophylactic measures should be taken in the event of a health emergency. So I would stress that that portion of the bill, even if it were to pass in some form, needs a little bit of work. Secondly, employers should not have to suffer the occasional cheater. Employers should be allowed to require justification for leave. Yes, it's after the fact, but employers then have some remedies available to them, such as discharging the employee, docking their pay, but employers shouldn't be at the mercy of employees, particularly since the bill is retroactive to beginning of the year, or the beginning of the emergency, March 5th, which in effect would allow employees to say, well, I would have taken leave but for, and thereby become entitled to take leave. That doesn't seem reasonable or equitable. There are other reasons to oppose the bill. We think if it were to pass as part of a larger package, it still needs a great deal of work. And on its own, we would recommend an unfavorable report.
Thank you. And thank you for your comments and pointing out the pieces. Christopher Costello.
Good afternoon, Committee Vice Chair Dumais, members of the Economic Matters Committee. Chris Costello, I'm here on behalf of the Howard County Chambers, 700 members. The Chamber is taking a position opposing this bill. They understand that everybody is trying to do their best to address the concerns of people who are being, who are obviously very distressed by one thing or another that is causing problems related to COVID-19. And it seems like there's so many different things and so many different ways to try and approach it. It's becoming very confusing and overwhelming. But, you know, adding on to this bill, the way this is being done is creating would create a great deal of trouble for employers. The purpose here may be to address these concerns related to COVID. However, it's written, this legislation could be applied to any number of other situations as determined by multiple health departments with the authority to declare and define such emergencies. Terms appear to be vague and may be subject to the interpretation which would play havoc with administration and enforcement. The bill is just overly burdensome and complicated. You talked about the amendments where there have been negotiation with these such things as agricultural workers and temp workers. I know people are saying this is terribly unfair and so forth and so on, but there were good reasons for doing that before. We think that doing this is going to create a lot of problems, and employers are going to have to make some drastic changes if this passes, all of which will hurt employees because they will either have to cut back on payroll, find ways to do with fewer employees, and as people have said, possibly move their employment out of state in one way or another. This is probably going to do more harm than good if you do it this way, and we hope that you think twice about it and possibly even think about an unfavorable decision. Thank you very much.
Thank you, Mr. Costello. Amy Rohr.
Thank you, Madam Vice Chair and members of the committee. My name is Amy Rohrer, here on behalf of the Maryland Hotel Lodging Association, requesting an unfavorable report on House Bill 1326. While well-intentioned, we are quite concerned by this bill, both from a financial and from a staffing perspective. Most hotels have only been able to remain open throughout this pandemic because of relief extended to us through the federal government, which has included 2 rounds of PPP funding. In the second round of funding, the dire state of the hotel industry was very much recognized, and hotels were allowed to calculate loan amounts at a higher rate than other industries. We were allowed to actually use 3.5 times average monthly payroll expense to calculate loans versus 2.5 being used as the multiplier for most other types of businesses. So the relief that we have received is a desperately needed lifeline, and we are trying very hard to make it last as long as possible. Adding any additional expense at this time will only shorten the lifeline that has been extended to us, which would increase the likelihood of additional defaults, closures, and unfortunate further loss of jobs within the hotel industry. Hotels that are open are operating with extremely limited staff in place, and this makes it very difficult to cover callouts. So we are concerned by the broadening of existing paid leave and the lessening of the employer's ability to request verification during a public health emergency. The provision of 106 days before a new hire can take leave is especially important to hotels that rely on seasonal workers. This is something that we worked very hard to negotiate when paid leave was passed, and this bill would remove that provision altogether during a state of emergency. You have my written testimony further detailing our concerns with the language, and we respectfully request an unfavorable report on this bill. Thank you.
Thank you. Colby Ferguson. Mr. Ferguson still here? Okay. Drew Jabin.
Thank you, Madam Vice Chair, members of the committee. Again, for the record, Drew Jabin here on behalf of the Maryland Association of Counties, here in opposition to House Bill 1326. We definitely appreciate the bill sponsor's opening comments and look forward to working with her as well as the committee on potential solutions. As written, this bill would place significant cost on local jurisdictions as a result of paying for the additional leave required during a public health emergency. For the public sector, many employees fulfill functions that are truly essential, and effective local government response to any sort of emergency is dependent on being fully staffed. Being required to offer an additional 112 hours of safe and sick leave per full-time employee, no matter how long they've been employed with the county, during a public health emergency, when public sector employees are needed most, is seemingly a costly and inefficient policy. The fiscal note already shows a potential increase in cost for local government, but these costs could be significantly higher as essential workers are often required to work additional overtime hours during emergencies to ensure the safety and well-being of Maryland residents. The bill does not appropriately balance the goals of helping employees with the economic realities that counties are facing, and accordingly make a request an unfavorable report on House Bill 1326. Thank you.
Thank you. Dana Kaufman. Is Ms. Kaufman still here? I know she was earlier.
Yes.
There she is.
Thank you very much, Chair Dumais and members of the committee. For the record, my name is Dana Kaufman, and I'm here on behalf of several healthcare clients, including the Hospice Network of Maryland, Lifespan Network, MINCA, and the Maryland Association of Adult Day Services. For us, this bill has two main provisions. The first one I want to discuss is that on-call repeal of that exemption. I was present and I did work on that exemption back when this bill was initially put forward, and that was a request by the health and human services industry. And the main reason for that is that it is a well-known practice in the medical field that businesses rely on these individuals to fill in for an absent employee or to cover under a special situation. But the key phrase in that repeal is that the individual does not have to accept that shift. And that's where it gets very tricky, and that's why the repeal went in. This category is very beneficial for both the employer and the individual because it provides the employer with quick coverage to ensure that it can meet the daily health needs of patients. But for the individual, it is also beneficial because it provides them with greater flexibility. For many individuals, it also allows them to maintain their licensure requirements for renewals. But one of the things is that oftentimes these individuals register as on-call or PRN for a number of employers. So the challenges that exists for trying to provide sick leave when an individual isn't required to take that job that day becomes almost insurmountable. The only other issue that I want to bring up is the fact of Medicaid providers. This bill does put a substantial cost on them, and that there is no offset in the Medicaid program or Medicare program for those providers. And that is a strong concern given the added costs that COVID-19 has put on those individual businesses. So thank you very much.
Thank you. We actually have another full page of witnesses, so I thought what we would do at this point is see if there are questions for the opponents that have testified so far. Not that you can't ask them later, but I just thought we'd see. Delegate Jarkoudian.
Yeah, thank you, Madam Chair. I'm not actually sure who wants to take this, but it's just one person. I don't want to take too long. I'm just trying to figure out what happened over the last year. How was it handled when folks needed to quarantine? So if their sick leave that they had accrued wasn't sufficient for 10 days or whatever it was that they might need, how were their jobs protected, or were they paid? Did they lose pay? I think I appreciate the challenge for the businesses. I'm also just trying to figure out how we make sure that we have the right health incentives, just from the broader pandemic perspective. I certainly heard from folks who felt pressured to get back to work, from not necessarily even from their employers, but because they needed the money and were afraid to lose the job and didn't have the guaranteed income. So I'm just, if there's someone who represents an agency that had, that could speak to what was done for folks over the last year who had to quarantine, how was that calculated? I assume they just took leave without pay? Did folks lose their jobs? What happened?
I don't see any hands raised, but there are a number of individuals on this next page that
Someone else could answer. Let me just, and then I think related to that also is several folks, Dana, I think Mark, I'm sorry that I don't know everyone rather impersonal like this right now. Just in terms of the other concern that I have that maybe you could speak to, again, is the pressure to show up at work, and again, in the healthcare industries, in the industries where folks are engaging around people who might be more medically vulnerable, and what's in place to support and encourage employees to take the quarantine when that's the appropriate steps for them to take, and they fear losing the income.
I can take that, Madam Chair, if you like.
Sure.
I think one of the important issues to remember is that healthcare providers are under CDC guidelines, meaning that we have to meet CDC guidelines. For many of my clients, in particular nursing homes, assisted living, and other senior care providers, we had orders that were issued by the Secretary of Health that required screening daily of anyone entering those facilities. So honestly, coming into work sick really was not an option. And we were required to provide and also maintain stockpiles of PPE. So I am not an expert in this one field, but I am going to say that there was the Families First Coronavirus Act that did require leave to be provided by those for those employees as well. So I do believe that many businesses, especially in healthcare as I represent, the last thing we wanted was a sick employee in those buildings because of the vulnerable individuals that were being cared for. So there were protocols put in place really from the beginning of the pandemic. And those protocols did change as we learned more about the COVID-19 virus, especially asymptomatic transmission.
So in essence, are you saying that we had some of these protections allowing for that quarantine and someone to not lose their job or to have the paid leave through the Families First Act?
I believe so, but I will also say that workforce shortages were something that many in the area of healthcare really struggled with, because not only did we have individuals who just left employment for a variety of reasons to care for their children, or who just did not want to work in that field anymore, but I'm not aware of anyone who basically fired somebody because they had to take sick. There
And I'm just
were,
wondering if, thank you for that. That's helpful. I'm just also wondering if people got paid for the time that they had to take under those other protections, as I think this bill would allow for. Thank you, Madam Chair.
Welcome. All right, let's go back to the testimony. Nicole Christian.
Well, thank you, Madam Vice Chair and committee members. Happy to be with you today. Nicole Christian, President and CEO of the Garrett County Chamber of Commerce. I'm here on behalf of our 600 members in opposition to House Bill 1326. We appreciate the concerns created by the pandemic, but we really do feel this bill unnecessarily expands the Maryland Healthy Working Families Act, and it places costly burdens on these businesses. The bill removes the agricultural and temp worker exemptions, and it expands the definition of a family member to include someone whose close association with an employee is akin to that of a family relationship. These expansions are needless and harmful, and neither have anything to do with a health emergency. The additional 14 days has already been mentioned as another costly burden. And even the Families First Coronavirus Response Act, which we just started discussing, only mandated 10 days of paid leave due to COVID. Additionally, the FFCRA provided the employer a reimbursement for that leave so that it was not a burden on the business. The current law really provides adequate sick and safe leave. It provides enough leave for someone to quarantine effectively if they were to have this type of health emergency. Employers also struggle with worker shortages during emergencies, and requiring them to provide more paid time off exacerbates the issue and increases those costs. Considering how the current pandemic has negatively affected most businesses and resulted in significant revenue losses, adding another 3 weeks of mandatory paid leave would be devastating. Additionally, as Amy Rohrer had mentioned, the requirement that an employer would have to provide leave for an employee who's worked less than 6 months for them, and they would have to estimate the number of hours that employee would possibly work in the future, is really excessive and unreasonable. And businesses still need help, not overburdensome and costly regulations. We are looking out for our employees. We're trying to protect their jobs, but when you add all these costs onto us, it creates a situation where we're going to eventually have to start laying off employees or reducing positions. So please give 1326 an unfavorable report.
Thank you. Lauren Callens.
Thank you, Madam Vice Chair and members of the committee. Lauren Callens with MAX, representing providers of community services to people with intellectual and developmental disabilities statewide. Here today in very respectful opposition, and hope to be part of ongoing discussions about this bill. We have a number of concerns about various provisions, which are all explained in our written testimony, but I want to focus today on just one, similar to what you heard from Dana, and that is the proposed repeal of the current exemption for what we call PRN, or relief staff, who are called to work on an as-needed basis in the health or human services industry and who can accept or reject the shift. These PRN or relief staff fill gaps in shifts not covered by our full-time and part-time staff. And this is a work arrangement that many, if not all, of them prefer because it provides them with complete control over their schedules, whether they work or not, the number of hours they work in a given week, and in the world of residential DD services, where they work. If there's a particular group home that they don't care for, they say no. One provider shared with me that when she offers good relief staff a full or part-time position with benefits, she is routinely turned down because they want the flexibility to say no to where and when they work and if they work. And Delegate Charkoudian and Vice Chair DeMay, this provision was removed relative to health and human services industry from the original legislation because of the significant operational challenges it presents for us. Though not clear exactly from the bill, presumably relief staff would have to sign up for a shift that needed coverage and then request leave, leaving the shift uncovered again. And most providers don't have enough relief staff as it is to fill all the gaps due to a staffing crisis that we've testified before this committee existed long before the pandemic and which has deepened over the course of the past year. This puts DD providers in a terrible position, given the health and safety mandate to the people with IDD whom they support and who must have staff support required by their plans. This would also put added pressure on the full and part-time staff who are already working enormous amounts of overtime and would decimate the fragile staffing safety net that relief staff provide. We are an industry that has long provided sick and safe leave to our employees. We don't want staff to work for a whole host of reasons when they are sick, but we support a population who must have staff and believe this change to existing law upends the very thoughtful and careful balance we worked so hard to create with the original sick leave bill sponsors and stakeholders. Thank you for your consideration.
Thank you. Mike O'Halloran.
Thank you, Madam Vice Chair, and good afternoon to you and members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran, here on behalf of NFIB Maryland, whose mission it is to protect and promote the ability of small business owners to grow and operate their business. NFIB Maryland opposes House Bill 1326, legislation creating a brand new section of paid leave under the state sick and safe leave law. It also reverses and removes, as you've heard earlier, some of the hard-fought compromises made during debate over the Healthy Working Families Act a few years ago. This committee has heard from many Marylanders today and in other hearings this session about the financial hardships workers have faced and many are still facing because of the COVID-19 pandemic. You have also heard from me and small business owners how they share these very same stories. Just as your constituents struggle to pay bills, small business owners are struggling to pay bills at their shops and restaurants in addition to their own homes. And I'd like to expand upon that point and why House Bill 1326 is financially impossible for Maryland small businesses by highlighting certain areas of the bill. On the issue of reversals to compromises laid out in the state sick and safe leave law, 3-1301 G12, page 4, lines 7 through 9, if you're keeping score at home, expands the definition of a family member to include virtually anyone an employee considers family. A few pages later, page 7, lines 27 to 30, 3-1306A1 ignores the determination of paid versus unpaid leave based on an employer's size for the purpose of this newly constructed leave. This committee decided 4 years ago, I believe actually, to acknowledge that our smallest employers, those with fewer than 15 employees, should not have to provide paid leave, paid sick and safe leave. There was an understanding that small business owners work with their employees to come up with other arrangements equally beneficial to both parties when an employee needs to be away from work. This includes paid time off. And Delegate Charkoudian, to your point, you know, it's the issue of whether a one-size-fits-all mandate like this should apply to every single business, and in this instance, regardless of their size. Frankly, the section ignores that determination by forcing all employers, regardless of their size, into providing almost 3 work weeks of paid leave to their full-time employees. For part-time employees and those whose hours vary week to week, the bill mandates an amount of leave that honestly requires a small business owner to either have a master's in algebra, know somebody that does, or have an abacus and a graphing calculator, because for the life of me, I could not figure out how much leave a part-time employee would be entitled to under 3-1306. In fact, the fiscal note just left it at in a specified manner. Paragraph C, D, and F under 3-1306 entitles, among other things, an employee experiencing symptoms that are oftentimes associated with the common cold to paid leave without having to provide any documentation to their employer. It's particularly concerning because an employer can require documentation for an employee's absence under the other leave allowed in the Healthy Working Families Act. Finally, 3-1306 C7, coupled with Section 3, not only sets up a logistical nightmare for small business owners, but a financial one as well. C7, taken with Section 3, explicitly states employees are guaranteed to pay leave from a small business owner, even though that business was forced to shut down by an executive order. I don't know how a small business owner who could have been shut down for the better part of the summer, unable to earn any money for his or her business, will somehow be in a position to pay 3 weeks of leave to all of his or her employees, even those who worked for only a week before the shutdown, as 3-1306B would allow for. it seems to me to be impossible. And as I said, and as every small business owner, I'm sure testifying here today will tell you, they understand the issues, the economic issues and the problems with paying bills. Heck, I've seen myself called out on social media because I've said that requiring this of small business owners is financially impossible. Because guess what? They are suffering the same financial problems. And as so many legislators have said, we are all in this together. But this bill, unfortunately, and the Essential Workers Protection Act is introduced, lays the financial burden of figuring this out solely at the feet of employers. So for these reasons, respectfully, Madam Vice Chair, NFIB opposes House Bill 1326 and requests an unfavorable report. Thank you. I didn't break the system, did I? I know I have a face for radio, but
I think the vice chair is frozen. Madam Vice Chair.
You did good.
Is Delegate Branch in the?
Delegate Branch? Yes,
Yes, ma'am. Here we go.
Okay, we're going to get the vice chair to log back in. Can we hold for a second, please?
Did it just stop on us?
It appears that a number of the participants are frozen, but if Delegate Branch, are you available?
Yeah, I'm here.
I think she's asking you to take the next person.
I can't see any hands.
Okay, Michael Halloran, I believe is the next.
Yes, ma'am. That was I'm the fellow that just presented that apparently threw a wrench in all the works.
Okay, is it Michael Halloran next?
Delegate Branch, I just went.
You just
Okay,
finished.
then the next person would be Kurt McCauley.
Thank you, Delegate Branch, members of the Economic Matters Committee, and I hope you get all squared away there. That things did sort of freeze up. I'm with the WMDA. We represent service stations, convenience stores, and repair facilities in the state of Maryland. And, you know, this bill is one of these one size fits all, and it just won't work. My businesses, all three of them, depend on traffic. Cars driving on the road, cars coming in to get gas, cars going in to get repairs. Well, that was off 75% at the end of last March, and it never has recovered fully. It has picked back up, but it's still way down. Businesses are breaking even or losing money. They've used PPP loans, and that surely has helped, but they've gone through their second ones now, and the recovery is not there yet. These this bill would you'd have to pay one $15-hour worker $1,680 plus your about 10% in federal and state taxes. A 40-hour technician at one of the repair shops, you'd pay $4,480 if he took off the leave, plus taxes. It's just undoable, and that's just one employee. When you multiply that times the people in the shop, where's the money going to come from? It's just not there. And this bill, the way I read it, emergency bill can be declared by federal, state, county, or local officials with authority. But would that account for a snowstorm? It just doesn't make sense, and it's very hard to understand. The part-time part of it, like Mike said, is very hard to understand. Programs like this will only enhance the march toward artificial intelligence add thousands of businesses along with their employees to the already succumb to the current emergency, people just can't afford it. And I'll stop there. I think everything else has been said by the participants. And thank you for your time. And I hope we can work with it. Thank you.
All right. Thank you, Mr. McCauley.
Thank you. Oh, you're back.
I'm back.
you're back.
James
Yeah.
Stark on a different computer. I don't know what happened, but James Stark.
Good afternoon, Madam Chairman and members of the committee. Thank you for your time. I'm Jim Stark. I'm the General Manager of the Best Western Plus BWI at Arundel Mills here in Howard County. I'm also the legislative co-chair for the Maryland Hotel and Lodging Association. I just want to echo the words of Amy Rohr from earlier in her testimony. For the hotel industry, this is all about economics and resources. I mean, the hotel industry was one of the hardest hit in the pandemic, and it'll be one of the last industries to sort of recover from the pandemic. And you can just look no further than the federal government with the last round of PPP extending PPP availability to us at 3.5 times our average monthly payroll versus 2.5 times. And that's not really to get us to break even or really sustain us. It's sort of a lifeline to slow the bleed for hopefully 6-9 months, really 6 months, until we can hopefully see the light at the end of the tunnel somewhat. I know for me, we're a 133 room hotel, again, in Howard County. And for months and months, we've had to put tens of thousands of dollars into the operation just to break even. I've had to lay off half my staff, the staff I have remaining. We're all family here. We take very good care of them. They take very good care of us. We have all the protocols in place. We provide all the PPE. We do everything we can to keep them healthy and safe so we can all keep coming to work. And I'm just here to tell you, me, and I'm the average size hotel in Maryland. The average size hotel is about 114 rooms. We do everything we can to keep our doors open and try to strudge our way through this, through every grant program, through every PPP that's offered, we take advantage of. And again, it's not even trying to get back to break even. It's just to slow the bleed. And it's going to be quite a while for our recovery. And that's why we urge an unfavorable report for this bill, just because, quite frankly, we can't afford it. It's very well intended, but unfortunately, when it comes to both sides of the table, one side of the table, really at the federal government level, they can print money. On this side of the table, we can't, and we just don't have any more left. Thank you for your time, and I'm available for any questions.
All right. Thank you, Mr. Stark. Kaylee Locklear.
Good afternoon, honorable members of the House Economic Matters Committee. Kaylee Locklear here on behalf of the Maryland Retailers Association in opposition to this legislation. As we have discussed before, the majority of businesses truly are good actors. They care about their employees, and they offered additional paid leave when they could. But as you heard earlier, even the federal government offered credits to help businesses with employees who had to use leave, and they continue to struggle for a variety of reasons. And the reason they did that is because they knew businesses could not shoulder such expenses. Additionally, this bill goes far beyond current guidance requirements or recommendations for leave seen anywhere for COVID without any verification, and it contemplates the exact same disease behavior from person to person for a future health event, which is impossible to predict. There are numerous issues in this bill, and Delegate Dumais, we are working on the emergency definition, but there are reasons for usage for paid leave we cannot support in this legislation. As I stated, they do not seem to be tied to current CDC recommendations for isolating, quarantining, or for suspected exposure, or follow precedents for whom leave can be taken, set by FMLA or other areas of the Maryland Code. Leave in this bill, for instance, and I think Mike referenced this earlier, can be taken for someone, and I quote, whose close association with the employee is the equivalent of a family relationship. And there's even leave in the bill for preventative care concerning a communicable disease. Being limited on time, I adopt the comments of my colleagues, and as many of you are aware, the legislature passed a paid leave policy years ago. And this bill on page 8 clearly adds this leave on top of that policy. It does not contemplate any federal leave provided, and also layers on top of FMLA. So for these reasons and more, we oppose this legislation. Thank you.
Thank you. Allison Zaborski. I'm sure I murdered that name.
Zaborowski, but you can say it however you'd like. I've heard it all.
Okay.
Thank you, Madam Vice Chair and members of the Economic Matters Committee. My name is Allison Zaborowski. I serve as the President and CEO of Leading Age Maryland. We're a community of not-for-profit aging services providers. So we serve residents and clients through continuing care retirement communities, affordable senior housing, assisted living, nursing homes, and community-based services. So our providers, as you can imagine, have faced increased and unbudgeted expenditures since the beginning of the pandemic. The cost of required testing, PPE, and increased pay for staff, including overtime and incentive pay, have cost providers hundreds of thousands to even millions of dollars. Nursing homes and other aging services settings are reporting operating losses of several $100,000 a month or more. These costs are necessary, and they have helped providers effectively protect and support both staff and residents. Some organizations have received federal and/or state funds to help offset some of the increased costs, but this funding has failed to cover the full impact of the expenses and lost revenue, leaving many providers facing significant financial strife. Across the country, we're seeing nursing homes beginning to close. House Bill 1326 places an enormous funding mandate on our sector at a time when our members and residents can least afford it. Here are just two examples. One of our members, who has 270 employees, estimates that this legislation would cost them an additional $434,676. Another member with 650 employees calculates it will cost them over $1.1 million to comply with this legislation. This would also put additional stress on our already strained workforce, which others have already noted in their testimony. There are not enough healthcare workers to support this. Hospitals, nursing homes, and other settings are all pulling from the same pool of potential employees. Finding enough clinical staff is a challenge, and this legislation would exacerbate these shortages further. For these reasons, Leading Age Maryland respectfully requests an unfavorable report for House Bill 1326.
Thank you. John Pika.
Thank you, Madam Chair. I respectfully oppose this legislation. I represent several nonprofits and several large private companies. And I want to touch on a point. I don't want to repeat anything that's already been said. I want to touch on a point that Ms. Lauren Callens made, particularly for nonprofits. You know, these companies that provide behavioral health services and work with special needs children have a model of a projected workforce necessary to provide services. And this would require possibly another 2.5 weeks for each employee. And they would have to rely on temporary agencies and employees who don't have the professional background to provide the kinds of services that these companies do, and then or that they provide. And then Mr. McCauley said one thing, and I'll wrap my testimony up. This is a one-size-fits-all, and it just doesn't recognize the diversity in the kinds of companies, the services provided, the sizes of them. I just don't think it works. Not in addition to, so for the reasons that it disrupts the workforce, as well as provides a financial strain on companies that are already experiencing significant reduction in revenue. I respectfully ask that it be given an unfavorable report. Thank you, Madam Chair.
Thank you. Melvin Thompson.
Thank you, Madam Vice Chair and committee members. I'm Melvin Thompson, representing the Restaurant Association of Maryland, and we respectfully oppose this legislation because of the additional labor costs it would impose on employers in our industry. As we've previously shared, the restaurant and food service industry continues to struggle to recover from the devastating financial losses related to the COVID pandemic and the government-imposed operating restrictions. This legislation would increase labor costs during a time when our industry simply can't afford it. Most of the positions in our industry require a replacement worker when an employee can't work their scheduled shift, which doubles the labor cost when a scheduled employee is unable to work. This legislation would increase those costs because of the additional paid leave proposed. And during normal times, the restaurant industry operates on a very narrow 4 to 6% profit margin. But during the COVID-19 public health emergency, Many full-service restaurants have seen their sales revenue drop by 50% or more. Imposing additional burdens will make it more difficult for restaurant businesses to survive. And for these reasons, we respectfully oppose this bill as it is currently drafted. Thank you.
Thank you, Mr. Thompson. Sarah Price. Is Ms. Price here?
She won't be testifying, Madam Chair.
All right, thank you, Ms. Locklear. And Mr. Ferguson, I had called you earlier, but I see you're back. So you'll be our last witness.
Thank you, Madam Vice Chair. Sorry about that. I have
It's
multiple
okay.
bills today. So I'm here on behalf of Maryland Farm Bureau, and we respectively oppose this bill. And really, we worked very hard back during the original paid sick leave bill to get the agriculture exemptions in there. And we worked to try to narrowly focus those exemptions to really focus on the small farmers, small farming operations that fell really into that under that 15 worker type piece. And really what this bill does is it strips that, not only that worker piece out, but then it also our farm exemption, but it also takes out the small operations. So really, I'm not going to get into to talk about what I think all the other opponents really did a great job of explaining, but it would make it extremely difficult for our small farm operations to be able to take on this it's what the existing was, and then on top of that, what's being added in for the pandemic components. So it's kind of a double whammy to us. So we would ask to at least keep that exemption in if the bill is going to move forward. So thank you.
All right, thank you. That concludes the testimony. Any questions? And I do thank everybody for testifying, and I think all of your comments will be, taken into account. We'll figure out when or how we're going to sort of look through this and see if there's something that we can work through to try and make a balance. And I do see Delegate Trakudian has a question.
Thank you, Madam Chair. I also appreciate the testimony, and I'm trying to think through the best way forward. And either to John or maybe Kurt, the comment about it's a one size fits all. I mean, by nature, usually what we do when we write laws is they are one size fits all. Like we set a law for the state and everybody follows it. So, but I'm wondering, I think the thing that I keep coming back to is we need to find a way so that people who are exposed can quarantine. And it is my goal to try to find a way to do that in a way that also protects them from losing their job and losing income or feeling like they need to come to work when they might be spreading that disease. And so I'm just wondering how else we do that, right? Like if one size fits, I mean, this is one size fits all, what would be the example of 3 sizes or 4 sizes? What would it look like if it was more flexible? Like that still allows us to say we've had a situation, we still do, and we could in the future have a time when people need to quarantine and we want to protect their jobs, help them make that safe decision for themselves, their coworkers, and their communities. So if this is the one size, what would size A, B, C, and D look like in a law?
Well, if I may,
sure, yeah.
If I may, Delegate Charkudian, you heard from such a variety of companies today and concerns or entities. So there's healthcare, there are nonprofits, there are people who teach, there are people who provide services for special needs kids and behavioral health services. Nonprofits can't be really compared to for-profit companies with less than 10 employees. And so I don't have the answer for you. If the chairman, vice chair of the committee were to ask some of us to get together and talk, I'm not saying the bill is difficult because like Mr. O'Halloran said, we didn't talk about the crush or the strain, the impact that this has already had on businesses. So being able to actually comply with it is going to be very, very hard. And it's going to create an economic strain for some, and some just won't be able to do it. I mean, who do you hire in an afternoon when you need somebody to work with special needs kids, or you need somebody to teach, or you need somebody to provide services to foster care children. I don't know that you can do it. I really don't.
And
One of my clients, I'm sorry.
What I'm saying is I appreciate that. I don't think there's any simple, I mean, we can't make laws, solve problems on bumper stickers. I mean, I get that things are complex. I guess the concern I have is that sometimes when we have a complex issue in front of us and we're trying to balance all of the pieces, the solution of opponents seems to be, this is one size fits all, therefore you should do nothing. And I don't think at this point in time we can do nothing. And I am open to, and I appreciate the conversation and this opportunity that we have to figure out what the right move is, and the vice chair's openness to working with everybody. I'm concerned that this idea that what we have doesn't fit for everybody, that could be true, but the solution in my mind isn't necessarily then we just toss it out. So then my question is, so what would flexibility look like? What would flexibility look like that would still support and ensure the kinds of protections we're looking for employees, for broader public health, and for the businesses, right? And so you don't have the business as a place where it's this super spreader event. So you don't have to solve all those problems right now. I'm just kind of pushing back a little bit on that idea that because this is one size fits all, we just don't do it, right? So, if you want
Delegate, if I can just jump in and offer, I mean, the narrative that you're laying out presupposes that employers are currently not doing anything, which is the farthest thing from the truth. They're doing what they can according to the what they have available to them. We talked about PTO, paid time off. A lot of employees offer those sorts of leave benefits that are even, in some instances, more generous than what's even laid out in this bill. So, when we talk about one size fits all, and I appreciate what you're saying, that, the legislature passes one size fits all mandates. It's the nature of passing laws. Well, look at the personal income tax brackets. That's not one size fits all.
Yeah, no.
So I guess it's just, and it's just the way you're pushing back. Certainly, I think the business community broadly is pushing back at what this pervasive sentiment that businesses are the bad guys. They need to pay for the economic crisis that this global pandemic has wrought. And the business community is simply saying, we're doing all that we can right now, and we can't do anything more.
No, I appreciate that, Mike. And the beginning of my question was, what would it look like to have 4 sizes or 5 sizes? To your point about like income tax brackets, like that. If it can't be one size, what does 5 sizes look like, right? I mean, that's kind of what my question is. If there needs to be more flexibility, then how do we lay that out? And you don't have to answer that right now, but I feel like that is some of the question that's in front of us about how do we move it forward. So but I appreciate your comments.
Delegate Jackson.
Thanks, Madam Vice Chair. Is the panelist that spoke about PRN still on the Zoom?
I think that was Ms. Kaufman.
Is she?
Or Ms. Callens, either one.
Are they still?
I don't see them.
Okay.
Still here.
Oh, there she is.
Oh,
There's
yes.
Ms. Callens.
How
Okay.
are you?
I'm well.
How are you? I just kind of wanted to clarify something that you spoke about. So you said concerning PRNs that if they were to get sick or something, what was your testimony concerning PRNs? They can just not come to work or something like that if they don't?
That's correct. So if a provider has a vacancy, that's what's today, Tuesday, if a provider has a vacancy on Friday, they go to their PRN list and they call, and the person can say, sure, I'll work, or nope, not this week.
Okay. Is it true in some cases PRN set their schedule maybe as far as a month in advance?
I guess that would vary by provider, how far in advance that scheduling is happening.
Okay, so when they do that, then they are expected to show up. Is that accurate?
Yes.
Yeah. And typically, if they set their schedule a month in advance, they're probably planning out how much they want to make for that month, you would agree?
I don't know whether it's being driven by licensure, desire to maintain licensure, or whether it's based on, financial obligations. It varies by person.
But it could be based on financial obligations.
Sure.
Yeah. So what happens if they plan their schedule a month in advance and don't show up? Would there be some recourse for them for not showing up?
Recourse in terms of
in terms of
benefits?
employment, in terms of being able to make another schedule? I mean, is there?
I guess it would depend on why they, what notice they provided to the employer, why they didn't show up. But, certainly PRN staff from time to time get sick too, and or whatever, and have reasons why they call out. But it doesn't happen that often. And most of them are called in on much shorter notice.
So I guess my concern is if we have a PRN who set their schedule a month in advance and they were to somehow get sick, you don't think that there should be any, leave available for them to, cover that loss that they would take based on the schedule that they planned a month in advance?
Well, I guess what we're saying is that there are people who accept a shift for tonight or for tomorrow. And
right, but I'm talking about the ones that set their schedule in advance.
Well, I don't know how we would manage that. This PRN list is a list of people who don't want to work permanently, don't want a permanent schedule, and who can say no or say yes, or sometimes they say, yes, I want to work a month in advance, and other months they don't say.
But what if
I don't know how we would figure that out.
Right. But what if they set their schedule a month in advance and then they were to get sick? Then what?
Then the provider would have to find someone else.
And Delegate Jackson, I hate to interrupt. My wife is actually a PRN, so I'm hoping I'm not stepping on anyone's toes. She's been a PRN for years and years. If she were to schedule herself, and she loves it because she has a flexibility in scheduling, if she were to schedule herself and get sick, she has one or two options. She can either remove herself from the schedule, and the hospital she works for would have to find someone else, or she would call out same day, which kind of throws a monkey wrench into scheduling for the hospital. But then she could take the time off that she's accrued, the sick time off that she's accrued. So that's a virtue of being a PRN, is the way that they do it. My wife does it because we have two young kids, is the huge amount of flexibility that's provided, but they are still offered the sick and safe leave, which fortunately, knock on wood, she doesn't get sick. She doesn't have to use, but that is available. Some of her friends that have had to do it, that call out last minute, they do have access to the leave that they've accrued.
Okay, thank you.
All right, thank you. I see no more hands. I really appreciate everyone taking the time to be here today and provide your input from the proponent's side as well as the opponent side. And you will hear from us as we kind of work our way through it. As I think Delegate Charkoudian mentioned, and I may have at the beginning, it's a series of bills that sort of are trying to deal with the catastrophe that COVID has had on employees, but also on employers. And as I said, I'm an employer myself. I do understand. And it will see if we can come up with something that's balanced, and we will, try and make sure that everybody has a voice. So with that, I think we are done for the day. It's not too bad. It's only 4 minutes after 5, but I appreciate everybody being here. Have a good evening.